Everybody. I get it. Good afternoon, everybody. So last week we were at the Blue Point face-to-face, for some of you at least. And today we are all sitting comfortably behind our computer to take the course. We will be in the company of Konstantin Jurgens. Konstantin Jurgens is of counsel in the EU and competition law practice group, and he coordinates the German desk of Garrigues. And Garrigues is an international law firm of Spanish origin. Konstantin is of German origin, based in Madrid, where he is right now. Last week, Henry Abbott introduced the procedural and institutional framework of EU competition enforcement. But today we will look at the main types of procedures and investigative powers, and it is in Regulation 1/2003. So Konstantin, thank you very, very much for agreeing once again this year to give this course. I am delighted to welcome you, even if it's at a distance, and I'm delighted to give you the floor, Konstantin.
Thank you very much, Charles. Very nice of you, this introduction, and thank you also, Valerie, for setting this up. And good afternoon to everybody. Yeah, I'm Konstantin Jurgens. As Charles has said, I'm based in Madrid. Although I'm a German trained lawyer, but I've been here already for about almost 19 years. And I practice competition law firstly also in Brussels in a few law firms, and then I moved to Madrid in 2003 or 4, something like this. And since then I've been here with Garrigues of counsel in the competition law department. I'm really happy to do this again. This session on procedural institutional question of EU competition enforcement. I would propose, if you have any question, I'm really encourage you to also step in and to raise question as we proceed. This also makes it easier for me, so I'm not talking all the time, which is already but I will already talk a lot in the next 4 hours or so. I would also propose that we more or less try to stick to the proposed breaks, say after 1 hour and a half or so for the first one, and then the second one later in the afternoon, let's say at around 4:30, before we close the session between let's say between 5:30 and 6 o'clock, if this is fine for you. So let's then start, if this is okay for you. Henry already has sketched out last week the main principles of this procedural institutional framework of EU competition law enforcement. What we want to do today is we want to touch upon the main types of procedures in a bit more detail than Henry did. So we think this will also fit in nicely in the whole setup of this module. We will also look at the general characteristics of proceedings. We're looking at question of proof, how you put forward evidence in these competition law procedures before the Commission, and then the last look is towards inspection of EU Commission information requests, which are the most important ones, and also we also look briefly at the end at the interviews. And as you are quite aware, Regulation 1 2003 decentralized to some extent the EU antitrust enforcement by empowering the national competition authorities and national courts also to apply in full Article 101 and 102, including as regards 101, 113. On this new system had two main consequences, so to say. It allowed the Commission to focus on the most serious infringement, and it also required firms to shift from, let's say, this notification mindset. I mean, this was the procedure up to 2003 that undertakings could notify agreements to the Commission with a view of getting approval for them. Moving from a notification mindset to a self-assessment mindset, which you probably already have heard about. And this way, it sets also up a system of cooperation between the Commission and the national competition authorities and the national courts, also with all these notices on how they should cooperate. And from a public enforcement, I think this is also fair to say, Regulation 1 has been a smashing success, I mean, this is also, this is a widely shared view. This is not only coming from the European Commission, because EU member states really have implemented. I think this is a valid statement. Have been implementing a true competition culture, and meaning basically that more than 90% now of all antitrust cases are taking place at the national level. So what we see today is also kind of, I wouldn't say that is kind of odd, but the Commission, since it could also focus on the most important cases in terms of enforcement, I think it's also accurate statement to say that the enforcement also nowadays lies to a large extent in the hands of the competition authorities at the national level. I think the for the if you want to start in looking at Regulation 1 and the main tools or procedures, I think it's also maybe a good start to take a step back and asking ourselves what could lie ahead, and this is how I put it in the beginning on this slide, Regulation 2, because people or the competition law community is also already talking about how this Regulation 1 2003 could be reformed, or could be even made better after more or less 20 years being in force. And I will not now dwell in too much detail on possible areas of improvement, but I just want to somehow maybe put forward certain ideas which we will see, which I want to flesh out over this presentation in the next three or 4 hours or so, and then you can also agree yourself or decide yourself whether you also would agree with these trends, no, that I would like to point out before we look at in detail at each of these procedures. The first feature is of Regulation 1 2003 is the development to a more, let's say, consent-oriented enforcement system, meaning that negotiate procedures are nowadays a really important tool, or if I even may say the most important tool now from the Commission. meaning that you already looked at Article 7 and 9. Article 7 of Regulation 1/2003 is the basis for the infringement decision. Article 9 is the commitment decision, and they have become one of the most common features of European Commission enforcement activity in recent years. And what has emerged really from this on the basis of these two articles, 7 and 9. Article 7 is also the basis now for this newly developed cooperation procedure, not only for the traditional infringement decision. And Article 9 is the commitment decision. What has emerged are these quasi, let's say, consent degrees. This is a notion taken over from the US system, which gives defendants often significant discounts on fines for cooperation. And this is what we call this transactionalization of competition law. And these settlements, usually they have been concluded primarily in respect of well-established theory of harms, where an absence of a clear-cut precedent is obviously not, or less of a danger. And what is a common theme about these settlements, be it settlement of a cartel proceedings, a commitment procedure, or the cooperation procedure, which I mentioned earlier, is that the defendant voluntarily incurs in certain detriment, because he basically also recognizes its implication in an or involvement in an infringement, competition law infringement, in exchange for some advantage, in terms of the outcome of the administrative procedure. And the benefits of the settlement is for both the Commission and the settling parties. The settlement is typically, and this applies across the board, typically less resource intensive. It's also saves costs, and it's a swifter resolution of market problems, which is also quite important for technology markets, where there we see whether these settlement procedures also have really such a big importance. But while settlement itself is not, or it would result unproblematic, because all the parties, be it the Commission and the involved parties, are better off. There has been also what we call this de-judicialization of enforcement, meaning that there are less court rulings on competition law issues. And this is also one critique. This maybe also be a downside to some extent, and this also leads us to the next point: paucity of precedent. Insofar as Article 9 decisions, and this would apply precisely for this commitment procedure under Article 9, they constitute private bargains between the European Commission and settling parties. But on the other hand, they do not expose or demonstrate really clear competition law infringement, and may, for this reason, do not really serve as a reference for market participants in the future. Because as you probably know, Article 9 commitment decision, they do not end with the competition law infringement, but they only see there's a preliminary assessment saying that there is a competition problem, but it does not say that there has been an infringement. And this also makes it somehow, this is better for the parties, but for all the other participants in the market, this makes it, let's say that this makes it less, or that could prompt other market participants not to use really, that they are not in the position really to use this case for their own behavior in the future. This is the first point. I mean, there is a lot of use of settlement procedures across the board, but this also comes with a certain costs. Then the next point that is also has been criticized, or which could also be an area of improvement in the future, is the reallocation mechanism under Regulation 1/2003, because you may heard from Henry already that, or you probably know from your practice that competition case, if it starts with the Commission, or let's say in Germany or Spain, it does not necessarily mean that it will end there. Competition authorities could refer the case to another member state, or they could, or various member states could refer the case to the Commission for an investigation. And there the question is really whether the parties can do something about this possibility, because sometimes you may not be that happy that if you dealt with previously with the Spanish competition authority, and the Spanish competition authority says, no, I think it's the Portuguese authority is better placed, that now the Portuguese authority will investigate this case. And this was also come to the fore, this problem now in this Amazon buy box case. That was the first time the European Commission, although it already investigated this case under Article 11, paragraph 6, which is somehow this the possibility or the basis that the European Commission is investigating a case and excluding all the other member states. There the Commission said, no, I want the Italian authority also investigate this case in parallel. So you had the European Commission and the Italian authority investigating this case at the same time. Usually there are authorities, national competition authorities, investigating a case in parallel, but the fact that the Commission, European Commission in Brussels, and the Italian authorities were investigating this case was really a novel development. And there the court said, as in the court ruling, that this is perfectly legal. The other thing we also want to touch upon is the remedies discussion. This is something which is not really received the attention it deserves in the discussion, because people sometimes think once there's a fine imposed on the companies, the game is over, and then we do not think anymore about how now the infringement is somehow removed, or let's say what the infringing party has to do to make good this infringement. And this is also something which is probably, especially in the digital new technology markets, which should receive more attention in the future, how the parties really should implement the infringement decision afterwards. Talking about Google, for instance, I mean, the fine was not really the problem for Google in this case. What was really more important for Google, but also for all the other market participants, is really what Google should do to comply with this infringement decision. And this is something which is which probably should also be more, which should receive more attention in the future. Then the other point is on comfort letters. This is something we will not really expand in great detail upon. You may have seen during the pandemic period last year, especially in the year before, these 2 years, that the Commission has implemented a so-called temporary framework, in which it also allowed the Commission to react to applications for comfort letter, meaning for certain comfort letter, on, let's say, an approval, an informal approval for certain supposedly restrictive agreements. So this is something basically which we had previously, that parties notified an agreement to the Commission, and then the Commission approved it or rejected it. There the Commission was willing to provide guidance to these parties, taking into account the special circumstances. And there have been 2 comfort letters in this during the pandemic, during the COVID period, which could also hint, which could hint somehow to a development in the future, that there are more comfort letters coming, because also Commissioner Vestager has also pointed out this possibility that the Commission will be more willing also to provide guidance for companies in certain situations. And then the last point, and there then we will stop as far as this overview is concerned, is this gap in Article 3 is concerned. You may have seen that there are various tools in Regulation 1/2003 that have not really suffice, let's put it that way, to ensure consistent application, especially in the internet-based markets, digital markets. There have been a few also, let's say, contrasting decisions of member states authorities. For instance, the German authority, they looked at more severely at price parity clauses than other competition authorities. And then the question is always, what can you do? I mean, to make it to improve, the mechanism for to ensure a more consistent application of competition law throughout the European Union. This is something which is especially by practitioners, which is complained about by practitioners, that the Commission somehow should also step in if there are 2 or 3 contrasting decisions. You may remember this booking case where the German Federal Cartel Office has taken also a stricter approach than other national competition authorities. And if the Commission does not feel competent, I mean, you have this possibility or this risk that there will be somehow contradictory decisions, and the question is how you could make it, how you could avoid it, that these situation arise. So let's then stop here as far as these overview is concerned, and then we will just now delve into the main types of procedure. We will look at the informal guidance in the first place. In informal guidance, this is something I already mentioned earlier. This is more or less what would be probably best described by this comfort letter tools, which is an expression that was used before Regulation 1/2003 entered into force. This was this somehow informal approval, informal guidance given by the Commission to restrictive or not restrictive agreements, notified to the parties by the parties to the Commission. And this stopped basically with Regulation 1/2003, and then the Commission said, no, this is now self-assessment. Companies should self-assess the impact of competition law on their agreements. SAFE, for these cases, and the Commission described it as the cases of genuine uncertainty because they present novel or unresolved questions. I mean, if the law is clear, then the Commission said, I mean, there's no need that we look into these notifications, and we want to concentrate our resources, focus our resources on the main serious infringement. And so this was perceived as a tool available to companies, but only in exceptional circumstances, if they are really novel and unresolved questions. And these three preconditions, or these preconditions for getting somehow guidance from the Commission was threefold. This issue should be novel, it should be useful, namely also in terms of economic importance. If it's only a minor issue, which does not involve also in financial terms a lot of resources, the Commission may not or will not usually be willing also to look into this. And the last point, which is also important, is the Commission. All the facts should be brought by the parties to the Commission. The Commission should not spend really significant resources on investigating the facts. This was all enshrined, these conditions in an informal notice, in formal guidance notice. But since 2003, I mean, as I had mentioned, until COVID, this has never been used for the by the Commission for the reasons we now want to look at. And one of the reasons probably is also that the guidance guidance letter itself does not really prejudge any later assessment by the European Court. So sometimes also companies may question whether it will really give them enough comfort if later on, if this then the matter is brought before the court, the courts will not really take into account, or maybe may take into account what the Commission had said, but they may not, or this letter, this guidance, or formal guidance issued by the European Commission will not have any binding effect whatsoever for in the market. The disadvantages is this is one important disadvantage. It is really doesn't really have any binding effect, and it's also not available on conduct that is no longer implemented. As the Commission does only want to look at behavior, conduct, agreement that are still being applied. I mean, you could also say that I mean, by looking at something which has already been applied in the past, the Commission would also give some guidance. But this is not how it was conceived to be in the beginning.
Konstantin?
Yeah.
Konstantin?
Yeah.
We don't see your slides moving, actually. I thought, so you are slides 5?
Now I'm on 6. Yeah.
No, yes, we don't see that.
Anyway, I'll stop and I'll see again. Let me check again. Sorry.
I'm sorry. Yes.
No, don't worry.
Thank you, Vivian, for noticing.
Yeah. Let me just check.
And if you prefer, I will do no work.
Yeah, I don't know why it's. No, you see it moving, or?
No. Okay.
You just check again. Sorry, I will just. Now you see it, or?
No, it's not moving.
Yeah, maybe if you can do me the favor that the let's see whether I can do it again. Let's see.
Voilà.
Yeah.
Try to change the slides to see if. Yes, no, that's perfect.
Yeah.
Yeah. Sorry.
Okay. Now you see slide 5, or?
Yes.
Yeah. Okay. Good. Yeah. Sorry for this interruption. Now you see slide 6. Yeah. Correct, or?
Yes.
Okay. Good. Thank you. Yeah, I was just discussing the disadvantages that the European Commission cannot any time open the proceedings if there's a complaint, even if it has issued previously such an informal formal guidance. So there's no guarantee really that this that no fine will be imposed, which also makes it less appealing for the parties involved. And the information which is also submitted by the parties can also be used in subsequent proceedings against the companies, and could be shared with the within the ECN network with other national competition authorities. And the so any national competition authority would not be prevented from opening the proceedings despite the existence of an informal European Commission guidance letter. I said in the beginning that now we had 2 comfort letters. And what people now already talk about the resurgence of comfort letter, because the Commission issued 2 comfort letters on agreements that supposedly in other times could really could give rise to competition law problems. This one was in Medicines Without Frontiers, where different pharmaceutical companies in different member states were basically agreeing on the cross supply of pharmaceutical products, and also in order to respond better now to the need that has been created through the pandemic or COVID situation. And the other one was about a matchmaking event for vaccines, also between pharmaceutical companies, which would probably in other times would have given rise to problems, competitional problems. But taking into account the exceptional circumstances, the Commission decided that this should go ahead. And taking the on this occasion, taking the advantage of situation, also Commissioner Vestager, she has said that undertaking also should seek sometimes guidance from the Commission, and then the Commission would also be willing to give this guidance. For instance, the example of telecom operators that would allow for horizontal cooperation on initiatives regarding the role of their network infrastructure. What also has to be said, even though there are there are only 2 comfort letters so far which have been issued, it is also true that companies seek guidance from the Commission, and even it does not maybe lead to the issuance of a document. The Commission also meet with them and also express opinions on certain conducts which will be proposed to the Commission for review. So even though in terms of numbers, we had only 2 comfort letters. The Commission is still giving this guidance on a constant basis. Now, turning to the next point, and which is also in practical terms much more interesting, interim measures. This is enshrined in Article 8 of Regulation 2003, and you may have seen, or you will probably be aware that in the practice of the European Commission, this has not really had a huge impact over the last 20 years since the entry into force of Regulation 2003, because because the Commission was not really willing also to use this instrument, and we will also be seeing what are the reasons that the Commission has been so reluctant until 2019, when it issued an interim decision in the Broadcom case. Why it was so reluctant to issue an interim, or to take interim measures. It's a powerful tool because also national member states, they use it a lot in the European Union. France is using a lot, but also Germany, and it's also basically it has a lot of importance also in markets where you really need to act swiftly, to prevent harm to competition, meaning where lots of economies of scale, networks effect, as in the digital market. So it is really useful in the Broadcom case. Actually, this was a case of the technology market, where evolving technologies are really of big importance. What do you do in an interim? What can you do in an interim measures? I mean, the most straightforward measure would be to say that certain behavior is prohibited. So where you really have a clear theory of harm consisting in, for example, a dominant operator should not use exclusivity, would simply say that this should be removed from all the contracts. So this would be a clear order to refrain from acting. But it could also require some positive action. This is also what the Commission has tried to do in one case, and but then which really came back to the Commission, and which was later also annulled by the European Court, that it should positively act. For instance, grant a license, or open up the infrastructure to other operators. But still, with this caveat, it's that it should only be of temporary and conservatory nature, and it only should be restricted to what is required in a given situation. The reasons why the European Commission has refrained from imposing interim measures have also to do with the fact that that Article 8, I mean, in the first place, does not really allow an application procedure. Interim measures are at the sole discretion of the European Commission. So even if you apply, I mean, the European Commission can take it into account or not, but it's not required to respond to any application. So the removal of the possibility for complaints might then also have decreased the incentive for complainants, because if complainants also see a risk that the Commission will not do anything, or that they cannot do anything about this possible rejection on the part of the Commission, that this then will also be could mean a disincentive for complainants really to appear before the Commission. The second point is also the cumbersome procedure, because after all, although it's an truncated, let's say that way, truncated procedure, an accelerated procedure, which also involves certain steps, which are also foreseen in the standard procedure, meaning that you have to issue a statement of objections. Before you have a fact-finding case, you probably also issue an information request. So you have all the different steps, but still you need to undergo the entire procedure. And it could not only be done by just taking the measure. You have to give the opportunity to the party also to put forward its views. This is done in a shorter period, but still these are different steps, and then the Commission might sometimes ask itself whether then it would not be better than to apply the standard procedure, because in terms of the time period, depending on the complexity of the case, this may not even be much easier than going for an interim measure if you still have the standard procedure also on the table. Yeah? I mean, if there's an interim procedure, you also usually open a standard procedure, and then the Commission also might be willing to focus its resources only on the standard procedures. And then and probably the main reason, although I don't know whether the Commission really will accept it or will put it this way, was probably the ruling in IMS Health, which was a setback for the European Commission, where the Commission went really far in applying interim measures. This was the case involved at the time. You may know the facts that involved in the German operator for what called 1860 brick structure, but was this kind of an data system which allowed tracking of the sale of pharmaceutical products in Germany, which was quite novel at the time, and which also, allowed pharmacies or market participants really to monitor and to manage in a much better way the sale of pharmaceutical problems. And IMS was a key operator, and competitors were left far behind. And there the competitors complained to the Commission, and the Commission, after concluding in an interim procedures that in fact what IMS did was somehow a refusal to an essential infrastructure, because IMS should have also allowed access to its competitors to this data system. The Commission required from IMS also now to open up this infrastructure and imposed a license on IMS. And this was what I discussed earlier. This was not only an action to refrain from certain measures, it imposed a positive obligation, which could pose problems in interim procedures, because you may even request certain things which will not even be imposed as a result of the standard procedure at the end. And this was annulled by the European courts, first before the Court of First Instance at the time, the General Court, and then also was confirmed before the European Court of Justice. And the Commission also had in the meantime removed the measures. But this somehow left the Commission with a bad experience in terms of interim measures, because it also, with reasons probably, it also feared the review of the European Court of these interim measures, because there the courts also somehow lowered the thresholds for reviewing the interim measures. It reviewed them on the basis of if there are serious doubts regarding the compatibility of these interim measures with European Union law. Then it would also, if there are doubts, this would be enough to annul, to quash the interim measures. And probably also this is a reason, if the Commission thinks or takes the view that even if I impose a measure, but then it may later be annulled by the European courts based on this lower threshold of judicial review, this would then also be this could be a problem, and it doesn't really make it appealing for me now to take these interim measures. And this is what I described here is the judicial review. What the applicant needs at that time, this was IMS, is to show that this is the existence of serious disputes or at least reasonable doubts regarding the correctness of the European Court's assessment. So yeah, you see that it doesn't make it easy for the Commission to adopt these interim measures. Now, looking at the requisite conditions for interim measures, this existed already before 2004, Regulation 1/2003. What I also mentioned, and there the Commission actually also applied interim measures on a much broader scale. All the case law, except now for Broadcom, which was the case of 2019, in which we also will look at in more detail a bit later. All these cases stem from the time before Regulation 1/2003 was enacted, and it didn't have any legal base in Regulation 17, which was the predecessor of Regulation 1/2003, but it was imminent. This is what the court said. Imminent in the within the power to take an infringement decision. The European Court of Justice established that the Commission has a power to take interim measures which are indispensable for the effective exercise of its function, in particular for ensuring the effectiveness of any decision requiring undertakings to bring infringements to an end. So meaning, if you can take an infringement decision as such, then you should be also allowed to take measures which will help you also to ensure the effectiveness of this infringement decision at a later stage. Always taking into account that it should not go beyond, it will be later implemented by way of the infringement decision. The conditions, and this has not really changed, are twofold. You need you probably will also know this from any other court proceedings, which doesn't really have to do with competition law. You need a prima facie case establishing an infringement, and there the European Commission does not need to show the existence of an infringement, but just the appearance or probability of an infringement, which also presupposes or involves a less detailed analysis, both regarding the underlying facts and also the legal arguments. So it should be, at first sight, there should be a case. Let's put it this way. And then the second requisite is urgency, an urgent need for protective measures, because otherwise there will be a risk of serious and irreparable harm to competition. In Article 8 now says precisely harm to competition. This was interpreted before Regulation 1/2003 was entered into force. It also already harm to one competitor could be enough, but now this threshold is also a bit higher, that there should be really an impact on competition as a whole. Potential damage to an individual in undertaking will only be considered if it really will irreparable harm to competition as a whole in the market. And these two conditions are somehow also interrelated, or interdependent. It also makes sense. I mean, is the more or the stronger the evidence for an infringement, probably then the less necessary it will be also to demonstrate that there's this urgency. So it is also somehow is these two requisites also somehow will influence one another in any assessment. Yeah, and the as far as the procedure as such, what I already mentioned, this also involves certain steps. I mean, you need to issue an statement of objections. You need to give the party concerned, the infringing party, the possibility to review the evidence, which is usually attached to the statement of objection. But this also needs to make sure that the addressee of the interim measures will also be able to exercise its rights of defense. And these two requisites now are specified or enshrined in Article 8, and the important takeaway for Article 8 is that that the EC, I mean, if you apply for interim measures to the European Commission, it does not need to respond to any application. No? It's not obliged to decide on informal requests for interim measures, or does not need to reject it by adopting a decision. What would happen in the last case if it's adopted a decision? This then could be appealed to before the European Court. But Article 8 has removed this possibility. They can also ask whether this is compatible with UE law, because previously the European Court has said that if the Commission rejects an application, then this could be also appealed before the European Court. But since now, with this legislation in force, this possibility has been removed. So you may take the view that is now somehow lowered, the protection for individual rights. But so it is. Yeah, since there is now an exact there's now an let's say a provision which specifies the possibility for interim measures, the Commission does not really now need to apply interim measures on the basis of Article 7, as a minus of an infringement decision. So every time there is an infringement decision, it will do so on the basis of Article 8. And in terms of how these interim measures must be construed or must be perceived, they should not somehow preempt the termination of the infringement procedure, of the standard infringement procedure of Article 7. It should not avoid that this Article 7 procedure then will become ineffectual or illusory because of the continuing actions of the undertakings concerned. I mean, this is a basic idea of interim measures, that it should only have a restoring effect on competition. The procedure is basically pretty much or correspond pretty much to the standard procedure, but in a much more truncated way, with the caveat that any that this letter informing the complainant that the EC, what we have seen over the last 20 years, does not want to adopt, the European Commission does not want to adopt interim measures, should no longer be considered a challengeable act before the European Court. If the Commission says no, you cannot do anything. You cannot do anything about it. Before the Commission can adopt interim measures, it has to inform the undertaking of its case and the factors demonstrating urgency, indicating also the measures if conduct is not stopped. Then the statement of objections should also indicate the measures the Commission intends to adopt if the undertaking does not cease its conduct. And the last point, which is also important for the undertaking concerned, the documents should be or the access to the file should be given to the party concerned, so that it can also be those documents are disclosed, on which the statement of objection is based. The time limit is much shorter for responding for the affected party, just 4 weeks. Could be also sometimes 1 week or 2 weeks. I think in the Broadcom case, which was the last one, was just one week. And then the interim measures as such, I mean, I explained or discussed a bit the IMS case in which the Commission imposed a positive action, in which it imposed a license, and which was kind of a drastic measures. The easiest way would be to take negative measures, but it's not confined to negative measures. If it's necessary to restore competition or to conserve competition until the standard infringement procedure has been terminated, then it could also take a positive order. Always on the basis of strict observance of the principle of proportionality, which is also a principle which is inherent to the application of Article 7 for infringement decision as such. So let me, before we close on interim measures, let me just discuss a bit this a Broadcom case, which was really the first time that the Commission, after IMS, after more than 20 years, imposed an interim measures. And just for this reason, it was kind of extraordinary. It also welcomed basically by the competition community, because it could somehow show that in the future, also after a couple of statements of Commissioner Vestager indicating that interim measures now maybe on the cards again, and that the Commission will always look at or will give the possibility of interim measures a bit more thought in the future, because saying that it could really help, especially in fast-moving markets, could really help to ensure effective competition. The case may also be somehow a book, well, let's say a school book case for interim measures, because it was based also on a clear-cut theory of harm. We will see it as this in a minute. It was basically based on exclusivity provisions, on exclusion of competitors, and discounts given to customers. So by just saying that there was an exclusion based on certain contractual arrangements, it was also easier now for the Commission to construct, to build up this case. What happened in Broadcom? Broadcom is a important operator, world leader supplier of TV and modem chipsets. you will have these little gadgets also, and in your at your place. Basically, those are the digital coders and these setup boxes which you have just placed next to the TV, and it's a ship. Basically, it's a ship maker, and it's these ship sets fabricated, produced by Broadcom, are used by telecom and cable providers at our premises, at consumer premises, and used for the setup top boxes, for set-top boxes, STBs and modems, and basically these boxes are produced by equipment manufacturers, and they use the chipsets from Broadcom. The conclusion upon a complaint from competitors, the preliminary conclusion from the European Commission was that Broadcom was prima facie abusing its dominant position. It imposed exclusivity and quasi-exclusive purchasing obligation, like rebates, to exclude competitors from these bids. Basically, what equipment manufacturers do is they organize bidding procedures, and by once it awarded the contract to these original equipment manufacturers, they were not allowed to deal with competitors. Yeah, this was basically the conduct which was challenged by the Commission, and in the procedure as such did not last that long. It was, I think, in less than 9 months or 10 months, it was over. The aim was to prevent serious and harm to competition in the form of elimination or marginalization of competitors before the end of the investigation. The Commission at the same time conducted the main procedure, but up to then it wanted to somehow to make sure that Broadcom does not apply these anti-competitive provisions in these contracts, exclusivity and fidelity discounts. Yeah? I mean, you have the whole range of tools that apparently Broadcom used to exclude its competitors, and that it should refrain from agreeing such provisions in other agreements. And the line of thought of the Commission, or the theory of harm, was that this conduct or these contracts that Broadcom used would also affect tenders launched by these telecom operators in the future, and that competitors, by giving then the contract to Broadcom, maybe also because probably it was in competitive terms, it was probably also a good product, would then be able would not be able to compete on the merits for those tenders, because these manufacturers will refrain from dealing with Broadcom competitors, and this would definitely then lead to the exclusion of these competitors. And once these competitors have exited, if they then it would be also difficult for them to re-enter the market. And given the timeline, this risk, this was the conclusion of the Commission, was imminent. The one thing which we also have to take into account is that once the Commission applied these interim measures, Broadcom at the same time started negotiations with the Commission on possible commitments in the future. This was an Article 9 procedure, and it was the first time that starting with an interim measure, the commission, the party, in this case Broadcom, used this decision so as to ask the Commission for solving the underlying competition problems in a much more, let's say, amicable way, no, by way of commitment. Broadcom challenged the interim measures, but at the same time, it started discussion with the Commission, and the case how it ended was that that Broadcom removed the appeal from the register of the European Court, and that it proposed the commitments, which later on led to the commitments decision of the European Commission. So you could say that by imposing interim measures, somehow it also the Commission provided an incentive to the company to consider or to contemplate measures how it could solve this problem, and then propose this remedy to the Commission, which was later accepted. This may be a blueprint for the future, but it's also an interesting case to see how the procedure that started out as an infringement decision could later turn into a procedure of transactional nature. What I said also in the beginning, lots of procedures before the Commission nowadays end as somehow transactional arrangements, be it a commitment decision, be it a settlement decision, which started off as in terms of cartel proceedings, or cooperation procedure under Article 7, which we also will which we will see later, which will also imply the grant of a discount on a certain fine. Now, going back to Broadcom, what are the main takeaways? That interim measures it depends always on the theory of harm. Here it was easier for the Commission because, and this is also why it chose carefully this case, because the competition loss problem was really readily defined. Yeah, this was these exclusivity provisions. I mean, the contracts really showed these exclusivity provisions and all these fidelity agreements. A case like IMS at the time, where there was the question of whether the competitor needs to allow the access to an essential infrastructure, would have been much more difficult nowadays, and this is why probably also the Commission, and this is the reason, as I explained, why the Commission refrained from these proceedings after IMS. In this case, this was probably a good starter for the Commission now to think about interim measures, because the theory of harm was kind of clear cut. And it's an exception to the rule that conduct by dominant or non-dominant companies is presumed to be legitimate until a breach of law is proven, until the standard procedure has terminated. And so it's this requires some effort also on the part of the regulator, of the European Commission. And the Commission has always said, and this also has been part of this ECN Plus directive, the competition authorities should not be overly shy in using interim measures, because it's a legitimate tool to solve competition problems until the main procedure has terminated. And this is this third point is something with what I mentioned in the beginning of this slide, that the combined use of interim measures and commitments decision is not really still somehow unexplored. It could be if it works like this, that if you impose an interim measures and the company itself is also or will be readier also to propose a remedy, this may be also a perfect tool or somehow a blueprint for procedures in the future. but it also has some shortcomings, because I mean, if you look at Articles 7 or Article 8 and Article 9, their nature somehow is a bit different. 9, you say that what you do not need is you do not need to pronounce yourself on the existence of an infringement. This is why you only need a preliminary assessment identifying certain problems. This is Article 9. So do not conclude in an infringement. Whereas Article 8 and Article 7, yeah, you conclude definitely there has been probably an infringement, probably in a prima facie case as regards Article 8. So this is somehow a conflicting nature, but apparently it could be combined. But it also makes it somehow a bit questionable whether the policy objective of an infringement decision is achieved by that way. I mean, you basically solve the competition problem, but you do not have is a decision later saying that it was wrong what Broadcom did, only as far as the interim measures is concerned, but it does not say, does not condemn to a certain extent Broadcom later to a fine and to a finding saying that that it committed an infringement in competition law infringement, because Article 9, this is how this whole story ended, is only where the company itself, in that case Broadcom, offers commitments which were then offered, which were then accepted by the European Commission. What I said is intermeasures you could somehow have the effect of a leverage for commitments, for somehow prompting or pushing the company into commitment procedures. But the question is always, and this is also a basic question which has to do with Article 9 procedures, whether this is always the best way of handling infringement cases, because as you may know, and we will later see that, commitment decisions are less prone to challenges by third parties. And usually, I mean, if you do all this, because there is a complaint and market participants have complained about this procedure. And the commitment procedure may somehow solve the problem, but often it does not satisfy all the market participants, including the complainant. This is why there have been also a couple of challenges of commitment decision over the last years, although there have been in most cases, I mean, except for just one case, they have been rejected because it's difficult to challenge judicially a commitment decision. Do you have any questions so far on informal guidance on interim measures?
Yes.
Yeah.
Yeah, Professor, I have a question. I would like to know if the undertaking have taken interim measures, and then the Commission will grant some discount when it imposed fine on the undertaking.
Yeah. This is a good question. This is done actually in this framework of the cooperation procedure. This is kind of a different, let's say, different playing field. If the company is I mean, first of all, I mean, as you said, if the company itself takes internal measures to make good on its infringement, this can always be taken into account as an attenuating factor within the one as a part of the fine methodology. Yeah, you could always say that I mean, you come up with a certain amount and then basically this is how fines are calculated. Then at the last stage, you look at attenuating but also aggravating measures. And then you can say, I mean, if it somehow collaborated by taking these internal measures, then we will offer an additional discount. But there is actually now a bigger procedure, which is now termed cooperation procedure within Article 7, where the Commission also puts forward certain evidence in saying, I mean, if you agree that you committed this infringement, I offer you 10%, depending on the infringement, 20%, 40%, up to 50% for just for acknowledging the facts as I have presented it, and if you take this or that this or that measure to make good on this, to make good this infringement. But this is somehow a different procedure, because it started off, the whole setting is differently. The Commission basically decides there is an infringement, but if the company, which is not in cartel infringement, because there we have settlement for cartel infringement, which we are now look at in a moment, there the Commission says this is a common competition law infringement, and if you acknowledge, and if it's applicable, if you take this or that measures, then we will grant you a discount. So this is how also this cooperation procedure basically is the basic principle of this cooperation procedure. Thank you for the question. Anything else, or? Then I will start before we break on just the two well, not start, but we move on now to different different tools for terminating an infringement, and this I mean, taking into account the discussion we had so far, you will not be surprised that we continue now with these let's say consent-oriented procedures. I mean, we still have to cover the settlement procedure and then the cooperation procedure. But just on the infringement procedure as such, which is probably now the standard procedure, Article 7, which is basically the main procedure, also as it was conceived to be in the beginning. But given that the Commission has also an interest always in somehow working more efficient, also making it easier also for the company to terminate the proceedings, clear forward Article 7 procedures, they are not that common nowadays, because settlement procedures for cartel proceedings make up already more than 50% of all cartel proceedings, and cooperation procedures and commitment decision have always played an important part, and that they're also increasing in numbers. If you look at infringement decisions, infringement proceedings, the important point in the beginning is that it only starts. I mean, we have two phases. I think also Henry talked about this. The preliminary phase. I mean, if it's talking now about the standard procedures, is when the European Commission is exercising its investigative powers. There, before really you are allowed also to review the evidence, or basically you're not allowed to evidence because the Commission is still investigating. Yeah, this is the preliminary investigation, and there you always have to somehow to strike the balance between the effectiveness of the investigation and the interest of the party concerned. And there the distinction is between a preliminary investigation where companies maybe can invoke. I mean, if the Commission sends out information requests and asks straightforward, do you have, usually they do not pose this question, but do you have committed competition law infringement? Companies can invoke the right, for instance, also to legal professional privilege. I mean, if you do not need to produce certain documents which will have been prepared by your legal counsels, and it carries a professional privilege, it can also invoke the right not to self-incriminate. But still, the defense rights do not produce their full effects to the extent that you are, for instance, prevented from seeing already the file, the evidence on file. This is you're only allowed to do once a statement of objection has been issued, because at that time you see that the commission has used certain evidence for making its case, and then you're allowed to see the basis, the evidential basis of this case. In Spain, for instance, it's different. Once already there's a procedure opened, you are usually allowed also to see to access the file. So this may vary from among the member states, but at the European level, you only the inter partes phase, which is called, only covers a period after the statement of objection has been issued, and then you're also allowed to review in full, I mean, subject to confidentiality obligations. You're allowed to review in full the evidence on used by the European Commission. Yeah, this is the this case. This is a recent case where this principle, that is only after notification of the statement of objection that the undertaking concerned is able to rely in full on its right of defense. If those rights were extended to the period preceding the notification, the efficiency of the Commission's investigation would be compromised, because you say that if the company then now sees or will have an idea of what the Commission is aiming at, then it also may be more difficult later for the Commission also to get hold of the evidence it needs to build up its case. Because if the affected party or the potentially infringing party sees what is already the information that is known to the European Commission, then it also may somehow obstruct this investigation by concealing certain pieces of information to the investigating authority.
Excuse me, I have a question.
Yeah, sure.
How does this standard work with the standard you referred in interim measures? I mean that the Commission has to show something for the infringer before adopting the decision interim measures. So the purpose of interim measure is to surprise the company, and here we have obligation to be confidential in relation to the infringer before adoption of the SO, and in the interim measure there is no such requirement.
Yeah, well, it's confidential. I mean, the obligation to keep information confidential, I mean, applies across the board. I mean, you also what I mentioned in the beginning, although you are totally right that the interim measures, the procedure and interim measures is somehow is a bit different in a shorter time periods, and probably also statement of objection is much more, well, it's briefer. It probably also focus on this point that the interim measures is aiming at, but the procedure as such is still the same, meaning that as in the standard procedure, the up to the issuance of the interim decision, this is a preliminary investigation, and there the Commission can investigate, and it's it's difficult to well, it's not possible for the company to access certain information because it's on file, but the company does not have the possibility to look at this file up to the statement of objection, and then it will be issued, and this is the same as in the standard procedure. The only difference is that the evidence will be much shorter and much more focused in terms of the interim measure, because it will also be like in the statement of objections. Sometimes it's also just annexed to the this was done in the Broadcom case, just annexed to the statement of objection. But the I mean, what you said, that the confidentiality provisions, they apply in all of these procedures. You mean that the you mentioned that there is a surprise effect by the interim measures? Not so much actually. The surprise effect, I mean, it could it may be or may materialize because the Commission is acting much quicker, and and maybe the fact that it issued a statement of objection interim case, this is a surprise as such, that it that investigated much more rapidly a case as it would have done in the standard procedure, because sometimes it takes on years before you do anything, before you issue a statement of objection in a standard case. But here, the surprise effect is only that I would say that the time periods are shorter. I don't know whether this more or less responded to your question. Yeah. Yeah. In terms of remedies, I said in the beginning that there's now a discussion what you can do in terms of imposing also remedies, positive actions in infringement decision. But as the rule is, and this is also what you see always in an infringement decision, as Article 1 basically is that there's a kind of a cease and desist order, that as if it not has been already the case, that the company should cease the infringement and desist from doing this in the future. And this always has been, this is in the Article 7 itself. It's stated, by decision requires the undertaking of association concerned to bring such infringement to an end, and this implies cease and desist. What does it mean, cease and desist? But the undertakings have not cooperated with the EC by cancelling their restrictive agreements or desisting from their unlawful conduct prior to the decision, or where it is not sure that the undertakings have in fact terminated the infringement. This is different than totally different story for the commitment decision. First of all, it does not say that as an infringement decision, and also for the cooperation procedure, which also was the first question which was addressed at this, or which basically related to also the cooperation procedure. There, probably the Commission would say, yeah, we acknowledge, or we take notice that there was an infringement, but that the undertaking has ceased this infringement. It's still an infringement, which is why it requires also imposition of a fine. But we take into account that the company has ceased the decision and has taken this or that measures, which leads us to grant a discount. Yeah, this is maybe different within this article, the application of Article 7 of Regulation 1/2003. Sometimes the Commission also takes it or wanted to make clear that the addressee should also be prohibited from adopting similar conduct in the future. But this is something you see less, because more or less it's quite clear, to the extent that it may have an effect or object as a conduct which has been found to be anti-competitive, may be repeated in the future. But usually, I mean, the basic idea is that there's a cease and desist order. What the Commission could also do is obviously behavioral remedies. But there, unlike to the EC merger proceedings, you know that the remedies, usually there's a strong preference, usually for structural and behavioral remedies. This is something you see less in infringement decisions. Because what is done usually is that, as you see, this also flows from the principle of proportionality, that the EC should not impose on the parties concerned a certain action, because the parties themselves should decide, because sometimes they also have more knowledge on this and more information, how they want to comply with the infringement decision. Although it's entitled to specific remedies, usually it takes a more, let's say, general approach, saying that the undertakings themselves should submit their remedy proposals. One of the most famous examples lately has been Google, where it was said in this Google shopping case, infringement was self-preferencing. Google was accused of using its own services, but then it should come up with a solution, technology solution, which would make sure that Google in the future will remove this possibility of self-preferencing. And it also somehow makes sense. This is something probably you should leave to the company, because they know how to implement this to a certain extent. Structural remedies, I mean, you hardly see in any infringement decision. There was one case in ARA, which was actually a cooperation procedure, where the company offered also a structural remedy. I mean, making some amendments also of the existing infrastructure, but this was only in the cooperation in the clear-cut infringement decision. This hasn't been really the case. I mean, it was a kind of a borderline case between behavioral and structural remedy. This is why I put here has not used its power to order structural remedies under Article 7. It was a kind of because it said that ARA was an Austrian provider for waste residual waste management. It made some changes to its existing infrastructure, also to allow competitors to make use of this infrastructure. And then there's also some reporting obligations. I mean, you have basically the cease and desist order, possibly remedies, and then the last point also there are reporting additional obligation. Sometimes undertakings. This was again also in this ARA case. This Austrian waste company must grant access to certain information or infrastructure, or also in terms of monitoring obligations, which later should enable the European Commission third parties to ascertain whether or not the undertakings change their conduct and comply with the infringement decision. And limits apply where the Commission attempts to regulate the legal relationship between the undertakings concerned and other parties, because they are generally to be determined under national civil law. This is also something we will see later in a commitment case. It's always difficult if the Commission also requires parties to change contracts, and then this will affect existing obligation with third parties, because this could also then lead or prompt the third parties to challenge the act, and then this may, the outcome of these proceedings is also sometimes difficult to predict. This is why also the Commission may be less willing sometimes to impose additional obligations to this extent. Yeah, and this is the basically more or less what I discussed in the beginning. You have seen this use of cease and desist orders, you ask yourself, especially in this Google case, 7 years of investigation, 3 commitment offers and 40 complaints, whether it's really then enough if you impose a cease and desist order and then you leave it to the company to come up with a remedy. I don't want to judge this in this particular case, but this is also how you look at these patterns. What can you really do in terms of remedies to make a market function? And probably the remedy, as I said in the beginning, the fine does not really, I mean, has a deterrent effect maybe, but for lots of companies, it doesn't change anything, and they'll because they want to, if they could continue afterwards their business in the same way after having paid the fine, then this will not probably change the competition law problem. And one of the important questions is always, can you order companies to take positive actions, not to undo that damage? In this IMS case, we've seen that the compulsory license to share your infrastructure with competitors is always difficult, because also it encroaches on IP rights, which was also a big problem in these proceedings, because IP rights also deserve certain protection. So this is something the Commission probably also thinks about, and the question is really, what can we do? How to better design remedies in the future? And then one thought is to use also use economics and behavioral economics to design better this kind of remedies in the future. Yeah, if you allow, then we would stop here for let's say 20 minutes. If this is fine with you, is okay, and then we will keep going now.
Yeah. Yes, that's fine. That's perfect. So for 20 minutes, you say?
Or 15 minutes.
Or 15.
Yeah, 15. Sorry, 15 minutes. Yeah.
So let's meet again at 26 then.
Yeah, very good.
Okay. See you later. Thank you.
Thank you. Bye-bye. Valerie, I will try again to share the screen.
Yes. Sure, it's a try.
Let's see how it. You see
Yeah.
it or? Yeah.
No, I see that you manage perfectly. Just
Very
try
good.
to move the slide so we are sure.
Yeah.
Yes, no,
Very
it's
good.
perfect. Okay, well, I will let you start because I see you have still many slides to go. So go ahead.
Yeah, but okay.
It's fine.
What do you say? 25, right? Or
yes, I was saying 26, but
yeah, maybe. Otherwise, I wait them for a minute, and then
okay. Yeah, it's 1 minute.
Yeah, very good. Let's move on. If you joined again, we will now look at two other procedures. First of all, the settlement procedures and the cooperation procedure, which I already mentioned previously, that make up the now the whole picture of possible commission decision, together with the commitment, which is also an important tool, and which I mentioned we also already saw in application in the broadcom procedure. The settlement procedure. This was introduced in 2008 in Regulation 1/2003, which was not actually provided for in the initial in the initial regulation, and it's basically an infringement decision according to Article 7, but reserved for cartel cases, and it's somehow is also a simplified procedure, which somehow takes on board what I described earlier, that the parties acknowledging or their misconduct or collaborating, and that in turn the Commission sees efficiency gains in reaching more rapidly the termination of procedures, and so also willing, in fact, to give credit to the company for its cooperation. So characterized by the acceptance of liability in exchange for reduction of fine. This is the basic idea of the settlement procedure, which is only reserved, I repeat, for cartel proceedings. It's a case closer mechanism and not an investigation tool like the leniency program. You probably will be aware of the already of some features of this leniency tool, which basically is used within the investigation period, the preliminary investigation period. It appeals to the companies to self-confess and to put forward evidence, which allows the Commission to put together a case for demonstrating that there has been an infringement, to put forward evidence, and in turn, the company later receives immunity of the fine, 100% immunity could happen, or 50% or 30%. But here we're in a different setting. There is already a case ongoing. There has been a preliminary investigation, and now the Commission looks at already the evidence collected. And then now it asks the parties, are you willing to settle? Yeah, so this is a different setting, and it comes in, it kicks in at a different point in time of the procedure. These two procedures can be combined. A leniency applicant, probably will then not the one who gets immunity. He could also be later willing to settle. So you could combine maybe a reduction in the fine for leniency application together with a settlement reduction. Settlement can only be reached in cartel cases, and because settlement also has to do with the nature of cartel cases, because in these cases the litigation or the investigation usually focuses on the value of the evidence, whether not so much whether the company committed the infringement, because there seems to be a lot of evidence. It's more about to what extent and what is the duration, and this is something which can somehow be negotiated between the Commission and the company concerned. There are now about more than 50, I think 55% or 57%, sorry, of all cartel decisions is up to 2020. I think it was last 2021. More about than 59% of all cartel fines since the first cartel decision is 2010. And with about more than 131 undertakings involved, you will see that in almost, I mean, all cartel cases now somehow in some form or the other are processed as settlement cases. What are the benefits for the companies? First of all, you have the 10% reduction, which is important, but it doesn't. It's not limited just to a reduction. What is equally also important is the limitation of the deterrence multiplier. If you calculate the fine, usually the Commission also applies a multiplier to increase the deterrence effect in the context of a fine. This is limited in this case. So this will also have an reducing effect on the fine. And then there are the let's say the other obligations, the other advantages, that it really helps both parties, the Commission on the one hand and the company, to earlier terminate the procedure. It puts behind the procedure more quickly and also reduces the damage to the reputation of the company. So the quicker you resolve a case, the less time you're also exposed publicly to this kind of proceedings. And then the also one advantage which also is getting increasing importance is that the settlement decision as such also will allow the European Commission to take this cooperation into account when it issues a public statement. If you read a settlement decision, an infringement settlement decision, you will see that it's much shorter, and the companies committing the infringement is much less exposed, also to maybe later on to possible follow-on cases for private damages before the court. It does not exclude these follow-on cases. Also, a settling party could be challenged later for infringement decision before a national court, but the decision as such provides less material, let's put it that way, for possible private parties asking for damages. You have a usually infringement decision, the pages, hundreds of pages long, and the settlement decision is much shorter and it does not provide that much detail, which also makes it more difficult for private litigants later on to claim damages before national court on that basis. And it helps also, I mean, this is also kind of a benefit within the nature of this procedure. It allows the company also to influence somehow the European Commission. The European Commission in the framework of the infringement procedure. The European Commission always said this is not a negotiation, the settlement decision. It's an offer made by the Commission to the company if it agrees with what we have, with what we are proposing. But somehow it's also there will be discussions, we will see now, which materialize in 3 meetings at least, and there you have a constant exchange between the Commission and the company, and so the company can also put forward arguments, and these arguments in principle will also have the ability to influence, you know, the outcome of the proceedings. When is a case suitable for settlement? As I said, this is not an offer, or this is not an application basically made by the company, and this is probably, it starts differently. The European Commission itself usually uses this discretion whether it want to pursue a case for settlement and on this settlement avenue, or whether it want to just pursue a clear-cut infringement decision with all the parties concerned. As I said, in most of the cases, more than half of the cases now, the Commission also opts for the former. It want to pursue a settlement case in cartel cases because there's always the prospect of using less resources and working less for a satisfactory outcome. And the idea is also that it should, in offering it to all parties, and this is also something which it takes into account, if there are lots of parties, then it may be also more difficult somehow to get everybody into the boat. And the possibility of a hybrid case, meaning that some settle and others do not settle because they are not happy with what the Commission is proposing, then it will be also more difficult. And then these are the hybrid cases, which also makes it more difficult for the Commission to pursue, you know, 2 different procedures at the same time. The most suitable case is a short and minor infringement with a limited number of participants, all of which are already cooperating with the Commission, or a clear-cut infringement that is supported by facts which are not disputed by any of the parties affected by the investigation. If in contrast there are a lot of high number of participants, because this also makes it somehow less manageable for the Commission, because you have always bilateral meetings with everybody. You do not have collective meetings asking with discussing with everybody in the room the outcome of the settlement procedures. You need to have individual meetings with each potentially settling party, because each party has its own case and its own stake, no, in this infringement procedure. And between these two examples, short and minor infringement with limited number of participants, case with higher number, none of which cooperates with the Commission, where there might be a very serious or long-lasting infringement, we're at the other side of the spectrum. This would be a case which would maybe not be prone or susceptible of being processed as a settlement case. But between these two extremes, there are a lot of scenarios that could be assessed on a case-by-case basis, taking into account also the objective of procedural efficiency. How are these settlement procedures are structured? It starts with the initiation of proceedings after the commission is investigating the case, and after the commission has already carried out a full investigation and now formally decides to initiate proceedings. What it does is this must be, otherwise there's no efficiencies involved. It must be before the issuance of the statement of objection, because in a settlement case, the statement of objection looks different. Yeah, it's much more curtailed, it's much more brief, and it's also focused on the fact that the parties concerned, the companies concerned, already acknowledge their liability. The commission may explore the parties' interest always in engaging in discussions. It does so after it had carried out this first review by setting a time limit. What it says is, look, we have made up our mind regarding this investigation. We think there's a case. If you are interested in settling, please let us know, and you have 2 weeks to decide on this. And once the company agrees, then we have this round of meetings. In general, 3 meetings, which we will now see in a minute. But that's important is that there are clear-cut time periods. The parties have to declare in writing whether they wish to engage in settlement discussions or not. This does not mean that they have to stay in these discussions, but they have to accept willingly to open the settlement discussions. And the declaration as such does not, I mean, this goes without saying, does not imply any admission by the parties of having already participated in an infringement. This will come later in the settlement declaration, or being liable for it. Only an interested, it shows only the interest in exploring the possibility of settling. Here we have these three round meetings. In between every meeting, there are also discussions, phone calls between the parties and the European Commission. In the first meeting, the Commission will present its assessment to the parties that chose to participate. It will also set out the basic elements: duration, scope, value of affected sales, and so on. So then this also gives the opportunity for the company to think about it, and then in the second meeting, it can also take on board what the company has put forward in the meantime. It presents its views on the arguments put forward by the companies, and then will verify whether there's now a sound basis for arriving at the settlement. And in the last meeting, in between a lot of phone calls and different discussions, then it will inform the parties of the estimate of the settlement fine that might be imposed. This is usually a fine range, between, let's say, I will impose you a fine between 25 million and, let's say, 35 million. Probably the range will be a bit smaller, depending now on the case. But since the commission, I mean, this is now the unit that is leading the case. The commission cannot say I will impose, or the case team, sorry, cannot say I will impose only I will impose you that fine, that specific fine, because this is later up to a decision of the entire college of the commissioners. So it only indicates a fine range. And during these discussions, a party can always opt out. The participating party can at any moment decide not to settle or revert to the standard procedure. And so can also the European Commission. If it has the impression that there's no willingness to settle, or that the parties are not forthcoming enough on collaborating, on advancing in these procedures, then the EC can also opt out and can say this is done. It has done so only once in one case. It was a smart card case where it said it stopped the discussion with all the settling parties. Sometimes only in usually what happens is that there are 2 or 3 parties that decide not to settle, and then the commission will pursue the standard procedure with them. But in one case, the commission said, I mean, I don't like what I hear from everybody of you in all these bilateral meetings, and then it turned, then it moved, and then it decided to close the settlement discussion. When a basic common understanding has been reached, the Commission can only go forward upon a formal request to settle of the parties concerned. So the Commission, after these 3 meetings, there must be a declaration of these companies, of the settling companies, who wish to settle, that they want to settle, and this must be submitted. And this text should include, first of all, the acknowledgement of the liability and the maximum of fine they are willing to accept, and the confirmation of having seen also sufficiently informed of the objections and granted the opportunity to make their views known. This is also important because settlement discussion will always include a waiver of certain procedural rights. You do not see the entire file, in the beginning. You only see the file that concerns now your liability. You also waive the right for a hearing. This is also another defense right you are announcing, and this is why it is important also to say that you are happy, with this waiver of your defense right. Yeah. So you do not request access to the entire file, only to the file to the extent that it was used for the statement of objection, and you are also waiving the possibility of a oral hearing. And once the settlement submission, this declaration is submitted, it cannot be revoked. And there you have reached the point of no return. Up to the 3 meetings, as I said, you can opt out, but once you submit the settlement submission, there's no way to go back, unless the statement of objection later, which the Commission then will issue, goes far beyond the parties, goes beyond the parties' acknowledgement in its settlement decision. If the company sees there's a mismatch, what I have said in my settlement submission with what is later said in the statement of objection, then there's a case of saying, and then the parties would revoke, or is able to revoke its submission. It hasn't done so in none of these parties. Usually what the Commission then issues is in line with what the parties have set out in these settlement submissions. If no settlement is explored or reached, then the standard procedure would apply by default, which is the case in these hybrid cases, which we'll see also in a moment. If there are 2 or 3 parties, often that do not want to engage in this in the settlement discussions. And the EC will then the statement of objection, and the statement of the objection is more or less already the final decision. It defines somehow the final decision, and there's sometimes it could happen in the standard procedure that the statement of objection is on. After all, it's only the first. It's the document of accusation, but this may later change. Also, taking into account the allegations of the parties later on, the oral hearing. So this may subject to certain changes. In the settlement case, it's different because there, what the statement of objection says basically is what will be also later reflected in terms of scope in the settlement decisions. The statement of objections, which I mentioned, it's compound. The parties do not really make additional allegation, the party should just reply by simply confirming that the statement of objections reflects their submission. Yeah, I mean, this is the efficiency gain, that the Commission does not engage again in discussions on whether they are liable, whether they agree with the facts or not, because this has been done previously. And if it does not reflect their settlement request, what I mentioned earlier, the parties will no longer be bound by their settlement submissions. Yeah? Usually, point of no return, but if the statement of objection doesn't correspond to what I've said, to what we have agreed, I have the right to withdraw. And the acknowledgement provided by the parties would be deemed to be withdrawn and could not be used in evidence against any of the parties to the proceedings. If this is the case. The European Commission then will adopt the decision, and the settlement reduction, what I mentioned earlier, can be accumulated with leniency reduction. So if you have a 30% in for leniency, since you collaborated also in providing evidence, you can add maybe another 10% on top, for getting a now larger discount in terms of fine. The Commission retains the right to adopt a final position which departs from its preliminary position expressed in the statement statement of objection. This has basically to do also with the fine. This is why the Commission usually does not say, I will impose you this amount. It indicates usually only a range, also to leave some leeway, for later some opinion of the advisory committee. This usually has to be discussed before the advisory committee, which is a representation of the member state, but usually they do not make any significant changes. But the decision on the fine is usually then taken by the College of Commissioners. No? This implies the decision-making autonomy of the European Commission. If the settlement procedure is abandoned, then the whole procedure starts again, and there will be then a new statement of objection, especially if this happens to those which do not settle. And then the possibility for the parties also to access the file, the entire file, and to request an oral hearing. Then you can invoke again all these defense rights which are available also during the standard procedure. About appealing a settlement decision, this is also something which I said in the beginning. This phenomenon or this trend of dejudicialization, meaning that that parties are less prone now to challenge decisions if they have agreed previously with the outcome. And this is something you see definitely here. The scope of the parties' litigation is limited because given that they're informal discussions, there's also less possibility now for mistakes that could lead now to an appeal against a decision being successful. I mean, if this is more or less basically discussed along in broad lines between the company and the European Commission, so the companies will not have any incentive now to appeal. Probably it won't help if they previously agreed to what was later set out also in the infringement decision. There are, though, a few judgments resulting from the appeal of a settling party, and they have usually to do with the level of reasoning for imposing fines. Since you do not know what the companies will be fining the amount the Commission will fine with respect to the other companies, are always bilateral discussions. Once a decision will be out, you will be, for the first time, you will hear also about the other companies and their fines. And then you may have questioned, why did they receive that fine and I got less discount? And this may be in ground for appeal. And this is why sometimes, and there are a few cases where companies actually made this kind of challenge. That the fine imposed was not properly be reasoned. And then there are also a few questions of which have to do with the characteristics of the bank guarantee. While you have to when you have to usually before once there is a decision, what you have to do usually is or you can do provide a guarantee to secure payment of the fine. But this has not been, I think there was only one case where this was really under subject to an appeal. The main cases are usually by appellants, settling parties, that have to do with the level of reasoning for imposing fines. And there the European courts also have annulled the reason, so decisions, because it considered that the Commission did not reasonably motivate its decision for a fine, always compared to other companies in the same procedure. In the appeals now brought against ordinary decisions by parties who preferred not to settle, this happens a lot if the company that has not opted to settle and then later received a fine, a larger fine that may be for sure a larger fine that has been discussed previously in the settlement decision, if it really participated up to the third meeting and then said, no, I want to withdraw. There have been a lot of appeals by companies that were processed in a standard procedure, and there the main outcome is even in this hybrid procedures, settlement decision and infringement decision, the courts have validated as such the legality of the settlement procedure. There's already also something because there have been few cases, but over the last cases, the first few cases have been arrived where the European Court said, no, this was properly done by the European Commission. And they gave also guidance on how, and this is also important for this hybrid procedure, and how the ordinary procedure and the ordinary decision, in the standard procedure, should relate to the settlement reached, because sometimes they run in parallel and then the decisions are taken on the same day, but sometimes this may also be consecutive, and this could now also lead to problems, what we will see in a minute. As I said, out of 34 cases where settlement has been explored, only one case has reverted fully to the ordinary procedure. This was the smart card case. In all the other cases, when parties have dropped out, the European Commission has chosen to run hybrid cases, meaning they took a settlement decision and they also took a rendered infringement decision. Now looking at these hybrid cases, which was probably one of the most fascinating features of the settlement procedures, because it gives a lot of food for discussions. And there are basically two methods, parallel or staggered hybrids. The parallel is really not the contentious issue, because there the two decisions are rendered on the same day, and it does not really imply a procedural question, as we will see in the minute. To begin with, if you look at hybrid cases, the fine ranges as what you sometimes the settling parties who have opted out the settlement discussions say later, you indicated a fine range of X, but later you imposed a fine of Y, which is much larger than what we expected. what is the response of the judicial courts to this question? That the fine ranges discussed during that settlement talks do not bind the European Commission as regards the standard procedure, which liabilities have yet to be determined. The Commission is only bound by the statement of objections against in this standard procedure. So as I said, it starts a new procedure. A new settlement of a statement of objection will be issued, and the cards are again on the table. And there, the Commission may also find different evidence in the investigation, which leads it also to impose later a different fine. Yeah. So what is said in the settlement discussion does not give any comfort whatsoever for any company who later decides to opt out of the settlement with regard to the fine eventually imposed. Yeah, this was in the team up case. It was discussed. There's no, let's say, legitimate expectation that the fine will be more or less the same. Regards the level of fine, the duty of the Commission is always to treat equally all parties to the same cause applies across the procedures, irrespectively of the different rules governing them and the existence of different decisions for settling and non-settling parties. The basic material for imposing the fine, the evidence, I mean, could be a bit different. The Commission could take into account in an infringement procedure, which is terminated later, also different pieces of evidence. But this does not, this should not lead it from not respecting or not to respect now the principle of equality between all parties concerned. And this has explicitly also an importance, equality between the settling parties. If a fine is imposed, different fine is imposed on the different settling parties, because this also has been challenged successfully by one of the settling parties in the Printius case, where the fine was annulled because the Commission did not take into account certain factors which it was willing to account in a case of a different settling party. Can the European Commission adopt two staggered decisions, the settlement decision and the decision addressed to the non-settling undertaking, without breaching its duty of impartiality, a presumption of innocence? This is important regarding now the timeline. This could be a problem, not in the event that there are parallel procedures, because usually probably the decisions are taken on the same day. But what happens, for instance, if you have the settlement decision before the infringement decision with the non-settling parties? There you have to make certain statements about the conduct also maybe of this party, because this could be necessary for building up your case. For instance, if you need to say that this company also participate in the meeting, also mean to make a case for this infringement in the settlement decision, this could somehow prejudge, yeah, the outcome of the standard decision, because you say that the parties should always have the opportunity also to review the facts which are alleged against this party. But if you already say in a settlement decision things about the company which has not been fined, or which has not been subject to infringement decision, what about the presumption of innocence, yeah, and the principles of impartiality? There, the basic or the guidance given by the European Court is that the distinction between description of the event and the legal qualification for the settling parties must be as clear, as sharp as possible. Meaning that these settlement decision needs to be carefully drafted, especially with respect to the non-settling parties. If it's necessary to make statements about non-settling parties in the settlement decision, then this should be only necessary, or to the extent that it's really necessary to say that there is an infringement, yeah, of the settling party, but it should not go beyond, yeah, this scope. And this was actually also the issue in now 3 or 4 procedures before the European Court, where the European Court was called upon looking at the settling decision, whether it said things about the non-settling parties, yeah, which were not, or which went beyond mere factual statements. The non-settling parties cannot expect that in settlement decision the deceit completely ignores certain effects admitted by the settling undertakings and relevant to assess the overall agreement, even when these facts also concern the non-settling undertaking. But it is entitled not to expect any declaration about its liability, because this is subject to different proceedings, to totally different proceedings or distinct proceedings, which will then be later be decided. And this also applies in these consecutive hybrid procedures, not on this in this parallel, where in the parallel procedures, which is also actually recommended by the European Court, that the Commission should always use its best efforts to take both decisions on the same day, which would avoid all type of these problems. In the end, I briefly summed up this type of procedures or set of these hybrid cases. Was this ECAP case, where the European Commission, was considered to have allowed the non-settling party to present its observation on the preliminary assessment sent to the settling parties before issuing the final decision in the settlement procedures. There, the court said the non-settling parties couldn't present its observation on the settlement decision, and so it said things, yeah, to which the non-settling parties could not take a position, and this did not lead later to the annulment of the decision, but it was clear that this conclusion was only valid because in the settlement decision, the European Commission had already made a formal finding that ECAP, yeah, this was this non-settling parties, had participated in the infringement. This was actually now the Commission also has learned how to draft the settlement decision. It cannot probably say anything about the liability, or it should not say anything about the liability of non-settling parties in a settlement decision, because then it will run into this kind of problem. So while drafting, precaution should prompt the Commission to avoid as far as possible naming the non-settling undertaking in the settlement decision. This cannot lead to prohibition on any direct and indirect reference. This was the subsequent case in Pometon, where this question was also discussed. Shall I refrain? No. Shall the Commission refrain from mentioning also non-settling parties? No. If it's necessary, these parties should be mentioned, but there should be no statement on their liability. No? And there's a key question is really whether staggered decision can be adopted without breaching the fundamental right of these non-settling parties, or whether it is not in a position to determine the liability of the undertakings participating in the settlement without also taking a view on the participation of the non-settling undertaking. Yeah? If I can only say something about the liability of the settling parties by mentioning also the non-settling parties, then there's an issue. But the question is always if it's really necessary. And nowadays, I think the Commission also has learned its lesson from this ECAP case, and now it's taking much more precaution on how to draft the settlement decision, and just refrain from mentioning the participation of non-settling parties, provided that we have two decisions, provided on the rendered on different dates. Yeah, yeah. Sorry.
Professor, I have a question in the hybrid case. If the non-settling party, they appeal the decision and the general court, and the general court announce the decision, can the settling party benefit from this announcement?
No, it's very good question, because these are two separate decisions. If it's if you mean if the non-settling parties will appeal, it does not its infringement decision. This does not usually benefit the other party, the settling party. No, because we have two different decisions, even if it's rendered on the same date. So you do not have one decision, one with settling parties, or decisions including one part for the settling parties and one part for the non-settling parties. Two different decisions, and usually those who do not have appealed, this is also a principle across the board, do not benefit from any reduction or from any annulation that any party may receive before the court. But it's a very good question.
Thank you.
Yeah, as I said, I mean, this hybrid cases, probably this always gives now material for thought, but there are now 2 or 3 decisions validating more or less also the Commission approach if there are 2 consecutive decisions. First the settlement decision and then the infringement decision, provided these settlement decisions are drafted carefully. And it's this is why it's probably there are more cases to come, because the non-settling parties will still, I mean, this is also why it probably opted out of the settlement procedures, is also probably quite willing to challenge any decision before the court. And then it may also, quite natural that it looks at the previous settlement decision, whether anything was said in this decision which already could have compromised its position, although it did not have the possibility, to provide its views on the on that decision. The last point, the settling parties will have limited opportunity to be involved in the contested procedure of the non-settling parties, and this is basically also the point that you mentioned in terms of before the court. And once you are out, once you're settled, it's difficult later to see how this case will evolve. Usually there is an infringement decision, but it also may end up with a different outcome. So this is also sometimes the risk you have to take if you decide to settle. Yeah, also summed up what we already discussed. As a settling party should be aware that the contested case against the non-settling parties inevitably result in an infringement decision that is significantly more detailed that the settlement decision. So this also may prompt then private parties to also to turn against the settling parties when it comes to private damages actions. They may use the two decisions because somehow they are, although there are different decisions, somehow they treat the same case. So it's not the if there's a non-settling parties in a procedure, those are usually also not good news for the settling parties, although it's probably better off because it will receive a lower fine. But when it comes to private damages actions, it's not safe before private damages actions in national courts. Settling parties involved in staggered hybrid case where the settlement decision is adopted before the contested decision are more likely to be the first target of follow-on damages. Although again, this will be done on this truncated, let's put it this way, settlement decision. Now they give less material for private damages actions, but it's already occurring. Yeah, it's happening that private parties are also turn against settling parties for private damages actions. And settling parties will not benefit from a successful appeal by the non-settling parties. What we discussed, if the appeal of a contested decision is successful, that success is limited to the non-settling parties. This was precisely also your question. So this is about settlement, which is a fascinating topic. If you have been or if you've been involved in one proceedings, I think the most interesting part is always these discussions with the Commission, these 3-4 meetings, and later on also to see how it is shaping up if it is in hybrid procedure. I don't know if you have any question on this settlement. Otherwise, we will move on to the cooperation procedure.
I have 2 questions, if I may.
Yeah, sure.
First, short one. In the meantime, while a settlement decision has been adopted and I decide to appeal that decision, do I have to pay the fine then?
Yeah, I mean, what you usually do is you provide if you appeal, you provide bank guarantees. Actually, is what I mentioned earlier. You can pay. I mean, usually the obligation is to pay right away. But if you don't want to pay, you provide bank guarantees. And then the question is, and this has been also a topic of discussions, if later the fine is reduced, what happens with the interest paid, whether they have the accrued, sorry, with the interest accrued, whether the Commission will be obliged also to reimburse the interest on this bank guarantee. But this, I mean, to respond to a question, yeah, you have to pay, but you can provide bank guarantees during the judicial appeal procedure.
And the second question is, if I decide to challenge the settlement decision for reasons because I might think that the Commission didn't even have the authority to investigate because a procedure rather belonged to a procedure in front of a national authority, and I lose that appeal, do I still then have the right to adopt that decision and get a 10% discount, or does the Commission have the power then to also abandon their settlement offer and say, okay, we are rather initiating the normal procedure and you're getting the full fine?
No, but I mean, if you probably what will happen if you, it depends on your challenge. It could be that I mean, this has not happened so far, that there has somebody challenge the decision on these let's say grounds of principle, that the Commission from the beginning should not have had the competence of investigating the case. This will be then too late, and this will come back against you, because this is also the essence of the settlement decision. What you could do is you can challenge, and the question probably is also whether these in the first place, whether these arguments are, or whether the pleas are admissible. But probably in the first case, you would be only probably allowed, I mean, to challenge issues that have not been totally clear as a result of the settlement decision. But I do not see that you that you can then, once you are that you are able to make this kind of pleas on grounds of competence if you agree to the settlement procedure before a court. I don't think this will fly.
So the decision, if I might agree on whatever reasons, and the appeal will be dismissed, I still have the chance to to adopt that as settlement decision or to agree to that amount settled later after, or is it like take it or leave it? As soon as you challenge the settlement, then it's gone for you, and the only chance is to get it.
Yeah, I mean, maybe I haven't understood you correctly. You said that what do you appeal, the settlement decision, or you appeal earlier this? Yeah. I mean, if you appeal the settlement decision and you do not, then you are not successful, then it stays like this, and then then you have to abide by the settlement decision, and this will not. Yeah.
All right. Thanks.
The cooperation procedure. This is something. Well, we still have two issues to cover basically in this for this consent procedure. We can do fairly rapidly. Consent-orientated procedure, let's put it that way, is the cooperation procedure and the commitments. Cooperation procedure is somehow embedded in Article 7 which is as I said, the full-fledged infringement decision. The only difference is that the fining decision is based on recitals. I think it's 37 of the fining guidelines, which allows the Commission to deviate from its own methodology in recent cases, in exceptional cases. In those cases, and the Commission has done so in these cases, in these cooperation procedures. The idea is it should not be in a cartel case, because otherwise we would be in a settlement case. But for the rest, it would be then a common competition law in infringement, but will also allow the characteristic of this procedure will also allow a rapid termination, because the evidence is clear. The more or less after discussions with the company, also the European Commission has arrived at the conclusion that the company is also willing to accept this infringement, and in return, the Commission then will grant a discount. And this could be, depending on the case, but I think it's said in the beginning, up to 50% even. Yeah? So it's much more than this 10% in these cartel cases. This may also be somehow or make sense within the methodology of this fining guidelines somehow, because of this deterrent effect, because cartel cases, as you will know, that the most serious infringement, and there so to ensure that there's still a deterrent effect, the Commission will not grant more than 10%. And this is it in cartel cases. You are not allowed to grant more than 10%. In these cases, cooperation procedures, there's much more leeway, because the Commission is not applying its own guidelines based on a perfectly legal possibility, basically the option to deviate in exceptional cases. This procedure can be differentiated from the commitment of settlement procedures. The settlement procedures was designed for cartel cases, and this one is not for cartel case, in which a settlement procedure is not appropriate, because otherwise there would be somehow, if it's not a cartel case, previously, before ARA, this was the first case in 2016, there was no such thing like a cooperation, unless there's a commitment procedures. But in a commitment procedures, the Commission does not want to pronounce itself on the existence of an infringement, in which a commitment decision cannot be adopted, either because the infringing behavior has already ended, or because the European Commission intends to adopt a decision finding an infringement. Yeah, this is the difference to the commitment decision. There are lots of cases where the Commission says, no, I think it's necessary to say that there is an infringement, but doing so, it could not do so via the commitment procedures. This is why it needs the cooperation procedure. What is the basic mechanism? It's more or less also reflection or adaptation to what we have seen already in the settlement decision. The company acknowledges facts, a legal definition, and liability for the infringement. It provides substantial also or clarifying evidence that it has committed the infringement, which will later also usher into a truncated statement of objections, which will also somehow adapted to the needs, no, of this procedure. The company is acknowledging its liability, and we set out now the facts of the case, but in a much more briefer and much more truncated way, as in a common infringement decision, which could also offer advantages for the company involved, because it also gives less material for private parties later to claim damages, on the basis of this infringement decision. And in ARA especially, there was also it cooperated also through the design and implementation of corrective measures. I mentioned that it allowed access to this infrastructure for competitors. There's a settlement notice, but there's no notice on cooperation procedures. This is only actually set out in a fact sheet, so-called fact sheet, in this GUS case. Also in the ARA case, it was also attached to the decision, kind of a memorandum in which the Commission explains, in the ARA case, for the first time why it chose this case as a cooperation, cooperation case. And there it also set out the principle which it thinks are relevant, to allow a termination of an infringement procedure by way of a cooperation procedure. It always depends on the case, which also makes it somehow difficult sometimes to detect clearly which case is suitable or not. But this also allows the Commission to maintain some flexibility in terms of which case to pick, for such cooperation procedure. The level of fine reduction for companies is based on an overall assessment. Timing of the cooperation, extent of the cooperation, procedural efficiency. There's a possibility also to offer a discount after the statement of objections. The cooperation procedure may kick in before and afterwards, but if it's in the latter case, definitely it's quite obvious. Then the fine reduction will be less, because they're only after the statement of objections the company has been cooperating, and whereas in a case where the Commission already could adapt somehow its statement of objections to this acknowledgement of guilt by the company, this also makes it, in terms of efficiencies, this makes it much more worthwhile then also to grant a bigger discount to somehow to compensate this cooperative behavior of the undertaking concerned. What are the main advantages? Cooperation may be useful for the European Commission because it helps it to adopt a decision more quickly. There's no timeline. It's just it doesn't say this has to be now to conduct it in, let's say, 1 year or 2 years. But what is obvious, the experience shows that these cooperation procedures, they take much less time than a standard procedure. It may also make gathering of evidence more targeted, effective, and expedient, because basically it's an invitation. I mean, if you want to help me, the Commission says, please put forward the evidence, and then I use it to draft then the statement of objections. And it also allows remedies which can be discussed with the company in this discussion. Otherwise, remedies there's only an exchange on point of views, different point of views in the commitment procedures. But this cooperation procedure also allows this possibility of an exchange between the company involved and the company and the European Commission. You can always, even if you're not on avenue of a cooperation procedure, the European Commission can always, within this finding guidelines, reward the disclosure of evidence through a discount of fine. But then it would be, it's a different story than the cooperation procedure. The cooperation procedure would probably mean, as a school book cooperation procedure, is that before the statement of objection, you come forward. This maybe effectively, this is not an invitation maybe by the European Commission, as in the settlement case, because it's, if you see that the Commission is investigating a case, you come forward and say, I may be willing to cooperate, and then it starts, and then the initiative could come from the Commission, but it could also come from you, after you have seen what the Commission is already investigating. Yeah, it's all about effectiveness of enforcement decision. It helps to reach more quickly, the end of an infringement decision, and the gathering of the evidence is much more targeted. In this ARA case, the question is also to what extent this is binding. Well, after all, it's an infringement decision, as any other infringement decision with these peculiarities. It will also bind court and national competition authorities, and could also achieve non-market tested and safer remedies. As you know, in commitment decision, before you impose or before you accept commitment, you have to market test them with competitors and customers. Here, there's no need to do this, because after all, what you do is you take an infringement decision and you do not resolve it by a finding of or simply by the acceptance of commitment. There's a need to market test your commitments. Here, this is not the case. So this is also a possibility or option really, or the advantage to ensure procedural efficiencies and minimizing the possibility of appeals. Usually, I mean, the same as in the settlement procedures, these decisions are not appealed by the undertakings concerned, because they have agreed to this procedure, and if it's in line with what has been discussed, it may also be it simply does not make sense then to appeal these decisions. And from the perspective of the undertakings, it's more or less the same as in the settlement decision. It helps you to leave behind the investigation, and you are and you get also a fine reduction up to 50% in this vertical cases. And as I said here in the last line, if you look at the precedent, the initial conclusion is that cooperation before the issuance of the statement of objection, in which evidence is provided, can be rewarded with fine reduction of 40% and 50%. Conversely, there's cooperation after the issuance of a statement of objections in which no evidence is provided, the final reduction is only 10 or 15%. As you see a difference. So it's worthwhile to engage in this discussion before the statement of objection is issued. Any question? Or this is the it's more or less a setup of this procedure. If you have it before the statement of objections, you have a state of play meetings, cooperation meetings. It's more or less, it resembles a lot these three-pronged meetings you have in the settlement procedures, technical discussions, and then you get more or less a fine range. It's you will get to receive a reduction of between 40 or 50% on, let's say, on a total amount of X, and then it's up to the College of Commissioners and then to decide on the fine. After the statement of objections, well, there's less possibility of collaborating, and then the consequences that also the discount will be less, in that case. Here I just summarized the few decisions well, there are quite a lot already. The ARA decision was the first one, and then in consumer electronics, Asus, Denon, Marantz, Philips, and Pioneer, they are remarkable to the extent that they have been offered a lot of discount, 50%, 40%. The cases also came out of these market investigation the European Commission has conducted within the internet economy. Clear-cut infringement, resale price maintenance, price fixing in a vertical relationship. So there was also not much to discuss on the part of the companies, which are also led them or prompted them also to collaborate. Then if you get 50%, and at the same time you change your contracts, and the issue is over, and you do not need to bother again about these issues. These are the famous cases. You see, cross-border sales restriction, geo-blocking is an issue always. It was actually after the Mastercard decision, was after the statement of objection. In Nike, cross-border sales restriction also in the internet economy, online sales of Nike, also a standard infringement, resale price maintenance. In this previous case, sorry for this, was the Philips and Pioneer case. And here in the RB InBev, this was cross-border sales restrictions for in the beer supply. Yeah. Those are the milestones. Express willingness to cooperate. It's much less formal than the settlement procedures. To say there are no clear fixed timelines. And so far, the Commission has not issued any guidance, and I would very much doubt that they will do so in the future, because it works like this. I mean, this also enshrines or somehow maintains the flexibility of the Commission to react individually to each of these cases. Those are the milestones which are set out in the decisions to the gas decisions. In the fact sheet, there it says this was after 2, 3, 4 years of these cooperation procedures in application. We need to express willingness to cooperate regarding the evidence on which the European Commission intended to rely on its decision. Then there will be a common understanding with the Commission, and then it's the Commission informs the company of the range of likely fines, and then the company will have to make a submission. It's like a bit the settlement submission, that it's willing to acknowledge the infringement subject to the imposition of the maximum fine, confirming that its right of defense was sufficiently safeguarded. The question is whether this is also the same point of no return. Probably not. What we said because there's nothing written on this. I don't know what will happen if this hasn't happened so far. What would happen if later on when the company will challenge the entire decision, saying that it did not agree with the or it did not say what is said in the decision. This remains to be seen how this will play out before the courts. And then the statement of objection is much more or less kind of a truncated. It's much more downsized, to that extent, downsized statement of objection than the standard procedure. And this is important. Point 6, that the company will just reply to the statement of objections. I agree with what has been said, or I do not have any comments. This is basically often the reply. I mean, we had this cooperation procedure here in Spain, where we tried to introduce it for the first time here at the national level. Well, you never know whether you have been the first one, because sometimes you do not really know how this later reflected in the infringement decision. But what we did in a case like this, we also basically agreed with the Spanish competition authorities on this main features up to point 6, and we said, no, we are fine with what has been said. Well, we didn't say we are happy with what has been said, but we do not have any comments on the statement of objection. And then the good thing about it is that also the Commission will not expand in such a detail about the infringement later. Yeah, and this also makes it more difficult for any private parties to use these decisions before national courts for private damages actions. It's a bit like the settlement decisions. Yeah, they are not that voluminous. They are you do not need to expose the entire case. Yeah, because you basically have agreed on everything. Yeah, on what is said, more or less, and this also makes it this gives a lot of value. I mean, if you look now at all these private damages actions hype going on in the member states, it also makes it a valuable tool, yeah, for companies to consider. Although, I repeat, it does not prevent any private party to use this infringement decision for its private damages actions. Very good. So if you,
yeah, Professor, I have a question. In the cooperation procedure, do the undertaking need to waive some rights, just as in the settlement procedure?
Yeah. Sorry, I did not get the last point. Sorry. Can you repeat?
Yeah, in the cooperation procedure, does the undertaking need to waive some rights as they did in the settlement procedure?
Exactly. It's the same. Basically, the same. You're also doing the same, more or less, as in the settlement procedure. Exactly. You do not. You only look at the evidence which has been used for your infringement decision. You also you will not request. You will not request a hearing as well. So it's the same. Yeah, good point that you also waive your defense rights. Exactly. Mm-hmm.
Okay, thank you.
Mm-hmm. So yeah, if you agree, then we will break for another 10 minutes here, and we see one another at 10 to 5 for the last hour. If this is okay.
Yes, that's perfect.
Okay.
Thank you, Konstantin.
So very, very good. If you agree, we will continue for this last hour or so. Commitments. When we touched upon these different procedures so far, settlement procedure, already also in the interim measures, and then cooperation procedures, I mentioned commitments because if you look at one, it's helps a lot to understand the differences or the setup of these tools. If you look at what has been the model pursued by Regulation 1/2003 in the beginning, there was no settlement procedure. It was only the commitment procedure, and there was no cooperation procedure. And the commitment procedure has somehow also inspired the other figures, which somehow try to keep up or to eliminate its weaknesses in a different context. I will come back on this. But what is the idea? I mean, it's also common to each of these consent-orientated figures. It enables the European Commission to carry out the procedures as efficiently as economically possible, because it also helps to save resources, because it helps it to terminate the procedure more rapidly. And for the undertakings concerned, it's the most important feature is, and this is the main difference compared to the settlement and to the cooperation procedure, that there's no finding that the company has infringed competition rules, which would be detrimental to this to its position, and this could also later be an subject matter for private damages actions. That doesn't work now. Let's see. Oh, yes, it works. What is the idea of these commitments? The proportionality principle, which applies to in the context of Article 7, is whether it's the measure imposed by the Commission is adequate to resolve the competition, the infringement, and whether it's necessary, and whether it's also proportional in a stricter sense, is different in the context of the Article 9 decision, because it's the company itself that comes forward and proposes the commitment. So it does the question does not pose itself in terms as it would mean whether this is really now detrimental, or this could be detrimental to the interest of the company, because it's the company itself that proposes this commitment, and the proportionality then applies to the adequateness, to the capability of this commitment to put an end to the infringement, to resolve the competition problem. This is a fundamental difference, and it also then makes it somehow makes it more difficult also for third parties later to challenge these decisions, because the question is always not if the company could have done more also to resolve the competition problem. The question is more than whether it was adequate to resolve the competition problem which was on the table. The types of commitment could be both, could be behavioral or structural, and there are couple of cases which you already have heard about. In the Beers Alrosa case, Bundesliga case, was somehow to extend the product, expand the product to offer the product to a greatest number of possible purchasers, not only to a limited number of parties. Opening up a possible distribution network so that suppliers can have access to distribute their products. This was these cases of the Repsol gas station network, or ending practices such as tying discounts for bulk purchases oblige clients to buy only that company products, no exclusivity in the Coca-Cola case. And there was also this Bundesliga case where the commitment resulted in a more transparent procedure to award the contracts for the transmission of the games. And there are a few other ones, Microsoft, Austrian Airlines. It always depends a bit on the industry. The duration of commitment, it could be 5 years, 7 years, 8 years. There's even one case, I think it was in Romanian gas case, where there was even any definite period stipulated, which means that they are open-ended. And very important feature is also that all the commitments are market tested, must be market tested. And this was also the problem in the Microsoft case. Excuse me, in the Google case, there the commitments were market tested, and I think in 3 different settings, 3 sets of commitment, and were later rejected by the Commission because there were so many complaints from competitors, yeah, of Google. Let me just one thing. I have to change here my gadget for the Can you hear me? Yeah. Do you hear me? Or
yes, we hear you.
Good. Thank you. Just needed to. The battery was low of my headset. And then the publicity of the decision making progress. There it's there the procedure is much more formal than in the cooperation procedure, where I insisted on somehow on this that the Commission has a lot of flexibility. Here, the Commission needs to stick to certain milestones. The preliminary assessment that there is a competition law detected, and then it has to market test later the commitments offered by which is accepted in principle. And then it has to market test these commitments, and the last thing that is also the publication of this decision together with the commitment. Well, also in the cooperation procedure and the settlement procedure, the decisions are published, but here it's somewhat different. That it's more difficult, maybe to a certain extent, to arrive at the end, depending on how these commitments are also perceived by competitors and customers. Here I already mentioned the duration. Yeah, in fact, it's the Romanian gas case where it wasn't specified. You will see if you look at these. Once you see it, also now it's probably you cannot read it that well, but most cases relate to the energy sector. Almost, I would say, 60% or 70%, where access to infrastructure is an issue, where geo-blocking contracts are also an issue. Somehow, if you do not allow that certain sales are made outside the given territory. I mean, you have the entire range, but there are certain areas, especially energy and to a certain extent also telecommunication, but more energy, that are more prone to commitment procedures. What is important about these commitment procedures, and this is something often also complained by third parties, because who usually trigger these procedures, that their rights are not properly taken into account. Complainant, basically, well, it could be that they bring up this case and that they also participate in these triangular meetings, if there's a triangular meeting, which means that there's a commission sitting at the table, the complainant, and the infringing party. Well, not the infringing party, but the party against which this procedure has been opened. And there, the complainant can also have the opportunity also somehow to influence the procedure. But this is it. It is not formally asked whether it later agrees with the commitments outside the context of this market testing in general. And sometimes the complainant is not happy about the outcome and may also have an incentive to challenge the decisions. Yeah, this could also happen. Actually, this happened, but of what I already indicated in the beginning, it's difficult to challenge commitment decision because of this of the way how this procedure is set up, because there's a lot of leeway on the part of the Commission to accept commitments if it deems these commitments adequate to resolve the competition problems. Usually the courts also leave the Commission a certain margin, to make this judgment whether commitments are adequate or not. Then you have procedural rights granted to the parties, undertakings concerned. You're entitled to different meetings. And then you will also have the chance. I mean, it's up to you basically to propose the commitments, which are later then market tested. What is also important about this, if the circumstances change, if these somehow the underlying pattern of facts change, there's always a possibility on the part of the Commission also to reopen the proceedings. This is foreseen in Article 9.2. What is really interesting about, I mean, if you get now to the hot issues in these commitment procedures, is the scope of judicial review. I mentioned this Alrosa case, European Commission Alrosa case, which was, its finding was later also confirmed in Morningstar against the European Commission, which confirmed the difficulty of appealing commitment decision, because the standard of review is somehow different. There, the court, the European Court of Justice, the General Court looked at it differently. But the General Court of Justice, which annulled the previous decision of the General Court, that the European Commission is not required to seek less excessive, from the point of view maybe of the party who has proposed a commitment, or more onerous solution than the commitments offered. If the commitment as such are susceptible, it could solve the competition problem, then it's done, and it's also not possible then to put in question this judgment basically made by the European Commission. So there is a wide margin of discretion, no second guessing of the European Commission decision to accept the commitments, provided, as I said, that they are able to remove the competition concern expressed in the preliminary assessment. And it's limited. This review is limited to establishing that the Commission has not committed manifest error of assessment. This is a formula which repeats itself in all these in these rulings, and more precisely determine whether a balance has been struck between the concerns raised by the EC, by the European Commission in its assessment, and the commitments proposed. Yeah, whether the commitments, as I said, are capable of removing the competition concerns. There is one. This has changed. This is this limited difficulty has changed a bit with one decision in Canal Plus of December 2021. The European Court of Justice annulled a commitments decision in the case of Paramount, the big Hollywood studios. There, what was at issue in this commitment decision? The Commission took issue with the prohibition of passive sales, of the possibility of passive sales for broadcasters and the studios alike. Meaning, I think in that case, Sky in England, should not respond to passive sales requests for certain programs outside the UK and Ireland. And on its turn, Paramount, which was the content provider to Sky in that case, should equally not to respond to passive sale requests outside the territory of the UK and Ireland. So it is basically a protection of the territory for the transmission of audiovisual content. This is always this constant preoccupation of the Commission, constant issue, this kind of geo-blocking that you somehow close up national markets, also in the audiovisual sector. There, these commitments, although affected third parties to the extent that Canal Plus in France had already had the same contract with Paramount, also enjoyed protection from third parties sales in France, but this was not considered in these proceedings. Canal Plus was not a party in these proceedings, and this commitment really went to the core of its contractual rights with Paramount. And this is why the European Court of Justice said, upon proposal of the Advocate General, which proposed a ruling to that extent, the commitments decision breached the principle of proportionality, because it negated these contractual rights of Canal Plus under the passive sales ban of third parties who were not involved in the proceedings, Canal Plus, prohibiting Paramount from complying with its obligations under the clauses in question undermined the party's contractual right to absolute protection. This was those parties, Canal Plus contractual right to absolute territorial protection. And this somehow contrasts with what we've seen in Alrosa. The Bears and Aros, the previous reasoning that the proportionality principle applies in a different way for this commitment decision. Is only what counts is that it resolves the competition problem. But the difference is that in Morgenstar and De Beers Alrosa, we did not have contractual third-party rights which were affected by these commitments. This was only in that case. This was only where there was also a third-party challenge in that case, but the case involved an interference with pre-existing rights, whereas in Canal Plus, whereas Alrosa, this case, the De Beers Alrosa, only confirmed future or conditional rights in the future. Beers in that case said that it did not like the commitment because it could affect its contractual relationship between the two parties, but it did not have at that time this contractual right. And this was a contrast, or this was a difference to this Canal Plus case. And this could somehow make it more difficult for the Commission in the future to commit or to accept commitments if it does not have a clear view on the contractual third parties right involved. If after these commitments there's a third party coming forward asking to review these commitments, it may have a problem, and this could also then lead to a less appeal, let's put it that way, also for parties in general to propose commitments, because if there's a possibility that third party rights may be affected, the Commission will be less willing to accept such procedure. Yeah, commitments will not be available provided they relate to existing contractual relations with third parties, unless the affected third parties have been also part to the investigation, and this was not case for Canal Plus, and agree to the commitments. Yeah, so you basically this could lead to expand the procedure and involve more parties in a commitment procedure, which makes it also much more difficult to handle this kind of procedure in the future. Parties may still be able to offer commitment that regulates future relationships and future commercial practices with third parties, even if those parties are not formally involved in the proceedings. It's true, but it's much more difficult than to agree commitments if it will be difficult also actually to involve the third parties in these proceedings. But if you're the affected party, if you're the one who would like to terminate the proceedings through commitment, you probably also you don't want to have all your customers and all your trading partners now line up in these commitments procedures. Yeah, then it will be this may then it may never end. So it's this is why the competition community as a whole, has looked with a lot of interest at this Canal Plus ruling, because it may change now a bit the whole landscape for these commitment decisions. If you look at the commitment decision as such, what happens if, for instance, now in let's say you have a commitment decision, and this was actually one case, Gazova, Repsol gas station, which basically said that all these agreements with gas station providers in Spain were illegal. It did not say that they were legal, but now I already said something which was actually couldn't be the case in a commitment decision. But it said that they pose competition problems, and Repsol later changed its contracts with all these gas station providers in different gas station providers in Spain. Now a party now used this commitments decision and for a private damages action, and said, I now want to private damages because I'm convinced that this decision the commitments decision also makes clear that there was an infringement. No, it doesn't say that there was an infringement, but what it mean now for the effect on national courts? Would a national court have to say, no, we take this is a binding decision, and I cannot now make a pronouncement on whether there was an infringement or not. What should I do? And there, this is already set in the regulation 1/2003, that the commitment decisions are without prejudice to the powers of the courts of the member states, meaning that a commitment decision does not preclude or does not prevent a national court from examining whether those agreements comply with competition rules or not. But the question is whether it will later lead it to say that there is an infringement, or whether it should somehow take into account that the Commission has not pronounced itself on the existence of an infringement. So what the European Court of Justice said in Gazova is that only the preliminary assessment should be regarded by national courts as an indication if not prima facie evidence of the anti-competitive nature of the agreement, meaning that the national court could still later conclude, yeah, if, in fact, there was an infringement. Yeah, so the commitment decision as such does not make these decisions impossible if now an affected party in a national member state, yeah, tries to turn against the party to a commitment decision in a national court. Yeah. And then the national court, is up to them to decide whether or not there has been a breach of Article 101 and 102. Yes. But always taking into account the principle of good cooperation between the European Commission and the national member state courts. It will not rush probably to a finding that there has been infringement, but it will also take somehow, will probably look at it closely and will review or will see whether that will be able to conclude there has been an infringement, because this is the very nature of the commitment decision. The Commission has not decided on whether there's an infringement. And if now the national court comes forward and says, no, there might be an infringement, this again may also be a problem for commitment decision in general, yeah, because it could make it less attractive if a party would need to face the consequences of an adverse finding on these commitments decision before a national court. Yeah, this was also actually addressed in the Canal Plus ruling, because Canal Plus also tried to challenge this decision in the before national court. And the question is really, does the commitment decision prevent national courts and competition authorities from deviating from the theory of harm and upholding similar causes in agreements between third parties who were not part of the EC proceedings? This was the question in Canal Plus. The European Court of Justice said, no, the national court cannot do this, but this is somehow questionable. This is why the European Court of Justice, has to decide in favor of Canal Plus, because a national court cannot do this. But if you think it until the very logic of this possibility of the competence of national courts also to review a commitment decision, I don't know whether the question related to this answer would be a clear no. The court in that case reasoned that by accepting the Commission, the European Commission expressed its intention to adopt a decision. And under the master food case law, I think also Henry mentioned it to this, national authorities and courts must avoid going against a decision that is envisaged by the European by the European Commission. There you see a bit of conflict with what the Commission, the commitment decision says, and with what later the national courts could decide or could do with a commitment decision, especially in these cases where third-party situations are concerned. What would have happened if Canal Plus had successfully challenged this Commission decisions before a national court? Yeah, what happened with the commitments decision? Here the European Court of Justice annulled the decision, but the question is also somehow open to debate what would have happened. Just the final thought on commitments. Up to 2000, let's say, 2019, before 18, 17. The European Commission used a lot these commitment procedures, and actually a lot of voices also said that there have been an overuse of these decisions, especially with respect to Article 102, because the downside of these commitment decision is, since there is no pronunciation on infringement, the downside is that there is also a positive, as I said in the beginning, a lack of precedence on what companies could do and could not do, especially with respect to 102. There's little case law on the obligations and rights of a dominant company. And if all these commitments decisions, of all decisions opened under 102, 85% at that time, since 2009 until 2018-19, ended up as a commitment decision, you do not really know what you are allowed to do and what you are not allowed to do, because the preliminary assessment, which later also does not become public, and only the commitment decision, where it somehow briefly describes what the competition problem was, you do not really get any clear guidance on what is allowed and what is not allowed. This has been a big, to a certain extent, a problem. And Commissioner Vestager, she has also recognized this problem, and said that we will only in the future, we only want to accept commitments decision if we think that this is really the appropriate procedure. Yeah? The question really is, why would the Commission allow a company to escape through a commitment decision when it has no doubt that it could have issued a decision, imposed sanctions, possibly fines? The question is really whether somehow the European Commission is not overly keen on accepting commitments, whereas it should have really pursued, also in the interest of clear guidance also to the market participants, it should have pursued the standard procedure of an infringement decision. And the question is article being used eagerly either to obtain unjustified results in cases that were not fully robust, and if private deals are closed now with companies just to get away with their infringement, because for the companies definitely it's better a commitment decision, depending a bit on the commitment, of course, but then an infringement decision. Yeah. But as a bottom line, also now taking into account the Canal Plus ruling, the European Commission probably will require in the future more information, especially with respect to third-party rights and greater legal certainty in relation to commitments, which might interfere with pre-existing contractual rights of third parties. Yeah? Otherwise, the risk of a subsequent challenge of the third parties could be considerable. I don't think that this is so much about now on the commitments procedure. I think now we have closed all these, let's say, again, consent-oriented procedures. I don't know if you have a question on, be it on commitments, cooperation procedures, settlements. No, okay. Then I would jump where we have rejection of complaints and declaration of in applicability. The letter, and I think this is why I don't want to expand too much on this. It hasn't been used in the past, not once, with these declaration of inapplicability. The idea is quite similar to the informal guidance notice, informal guidance letters. The Commission is basically provides guidance on certain conducts, but in a much more formalized way, in so let's say quasi legal regulation, because in the interest of in the public interest, the Commission could say, this is foreseen in Article 10 of the Regulation 1003, that a certain conduct does not infringe Article 101 or 102, as it may be applicable. But so far, for the reasons we may also recognized, the Commission has not used this instrument because it always said that these requisites really a necessary public interest, really important conduct in economic terms and so on, that all these requisite has not been fulfilled. So this is why in practice this declaration of inapplicability has not given rise to any meaningful practice, and which why also prompt us now to more or less neglect it and not to go into much detail in this respect. There was this discussion during the COVID pandemic whether there might be, even for certain sectors, might be interesting to revert to or to resort to an Article 10 procedure, but it hasn't done so. Yeah. This is all so much about on declaration of applicability. Rejection of complaints, I only want to mention it here because it also, in contrast now to the interim decisions, where you have an applicant for, where we have an applicant maybe for an interim measures, but where the Commission is not obliged to respond, as far as rejection of complaints is concerned, there the Commission is obliged to respond, and you have later a decision which is subject to legal legal appeal before the national court. This is a basic difference. Once you make a complaint, a general complaint, the Commission gives you the opportunity to first to set out your facts. If the Commission does have doubts or want you to expand on the facts, then you have a second chance. These are the Article 7 letters. And then if you are not capable of substantiating your complaint in more detail, and it doesn't lead the Commission now to pursue a case, to open an infringement procedure, then it will adopt a decision rejecting the complaint, and then you can appeal before the European Court. What happens with these appeals? Most of them are also rejected because, as we said also in the beginning, the Commission is always enjoys a lot of discretion as far as rejection of complaints is concerned, because we have a system of national member states that are also investigating complaints, and then there's one consideration that the Commission is not the best placed authority to conduct this case. You can always turn also to different member states if it happens in one of these national member states concerned. And there's also this notion of EU interest, which also allows the European Commission to reject cases for which it simply does not have any interest. Yeah. So, which is why, I mean, this is in a nutshell, but I think this basically sums it up. What we what would be the subject matter of the rejection of complaints. And what I would do is then to jump to now to close on our, in the last half an hour or so, to slide 88 and the general characteristics of the proceedings, which also somehow refers us back to what I said in the beginning about the preliminary investigation and also the inter partes investigation, and to what extent the European Commission needs to observe certain principles of sound administration, transparency, legal certainty in which phase. Yeah? I think Henry also last week already explained a bit this the context with the of fundamental rights of the Commission acting in a framework also that touches upon fundamental rights. And the first finding of this is, or the first statement, what we can make about the European Commission, that it's, first of all, it's an administrative authority, and is also somehow circumscribes its function. It's not a tribunal within the meaning of Article 6 of the European Convention of Human Rights. And its function are legislative, administrative, and political, and to the extent that it enforces competition law. But it's in the first place, as up to in the preliminary investigation phase, it has a lot of leeway of conducting its investigation. It's clear that it should always conduct these procedures in accordance with the Audi Alteram Pactem, but this only really applies as of the moment of the once the statement of objection is issued. Then it needs to open the files also to the company to show what evidence it has against a certain company. More or less, the proceedings in competition matters are now quite similar to those available in judicial proceedings. The question is always whether they are similar to criminal proceedings, and there are lots of still differences also. But as far as the use of burden of evidence is concerned. What are the basic elements? You have two notions: the burden of proof and standard of proof. It is always somehow confusing perception of what is what. Burden of proof basically says who needs to put forward the elements, to allege that the fact has happened. As this is for an infringement case, European Commission bears the burden of proving the elements of the infringement against relevant companies in antitrust cases. This is the first element. Then once the infringement has been proved on that basis, the company has also the possibility to invoke Article 103, which is the exemption if there's overweighing effects, pro-competitive effects with respect to an infringement. There, basically, in this ping pong, the burden of proof kicks back now to the company. It has to allege the facts showing that effectively the exemption of the prohibition applies, in a given case. What is in contrast to this, the standard of proof? The commission, or basically the authority, regulating authority, it satisfies the burden of proof if it is able to meet the legal standard of proof, meaning that it must adduce evidence which is capable of demonstrating the existence of facts constituting an infringement. So you see that the two notions are connected, but they are not the same. Burden of proof says basically who has to allege, and standard of proof is what is required to prove that a certain conduct has occurred. This means that the evidence relied upon should support the firm conviction of the veracity of a given or objection that the company has held liable, must have been able to exercise its defense rights during the administrative proceedings. This is the principle of the necessity of being heard about all the facts that have been alleged. I only want to briefly discuss a few notions, because I think it's also interesting on this cartel investigation and evidence of proof, and these notions how they interact: burden of proof, burden of adducing evidence, and the standard of proof, presumption of innocence, because it's somehow it's quite close nowadays to what is required in criminal proceedings, but sometimes it is not, and you see it clearly sometimes in the commission proceedings, and then also challenged before the European Court. What is really the question often, and I think you can really summarize it like that, that it's not the question of whether a certain piece of element is admissible. The question is more whether it is really reliable. Yeah, the reliable before to demonstrate that is certain that a certain fact has occurred. You see this in lots of decisions. For instance, if the European Court lately had to look at private recordings of phone conversations, and the Commission got hold of these private recordings in an inspection on I think it was in Holland, in the on the premise of a company, and later, and as everybody would have done in their shoes, this company alleged that this private recording was made against its will, and that the Commission is not should be prevented from using this piece of evidence. What was the response of the European Commission to that? And there you can see it. There's really a difference of whether something is admissible or whether something is reliable. The European Court said, following the reasoning of the European Commission, no, the European Commission was not involved in recording these conversations. So you cannot allege that this should not have been used. It found this evidence, and as long as the company itself is later able to provide its views on this recording, there shouldn't be any problem. Yeah? As you can see that there is, and to this was added that this private recording was not the only piece of evidence showing that there was an infringement. Yeah? You could see that in these competition cases, you look at a whole bunch of different pieces of evidence, and you sometimes do not really raise a question whether this piece of evidence, as you would do in a criminal proceedings, whether was this now retrieved or was collected in accordance with with all standards of a legal procedure according to the member states. The Commission itself, clearly, if it does conducts an inspection, it needs to follow, it needs to comply with its own rules in collecting evidence. Yeah, this is true. But if it finds itself with this piece of evidence in which it did not intervene previously, in principle, it could use this document, as long as later on in the proceedings, the company itself is in the position to provide its views on this document. Yeah, that is just only a side remark on how this how these things could look different in a context of a criminal proceedings. Yeah, where this probably would create many more problems compared now to this competition law procedure. As I said in the beginning, burden of proof rests on the authority regarding the constituent element of a cartel, and the undertaking as such, it is also important, cannot just take a passive role and say that it only challenges the fact. If the Commission says you participated in this meeting, here's the record, the company needs to come forward and provide its views on why it thinks that this is not an accurate conclusion. So it cannot just stand by and just do nothing about, but just saying no, I don't want to respond to this, which would probably could help somehow in the criminal proceedings. The standard the evidence is what I said earlier. It's not so much about reliability, but it's about admissibility of evidence, reliability, quantity and quality. If there are sufficient pieces of evidence, coming together that later demonstrate that this infringement has taken place. Yeah. So an authority must produce sufficiently precise and consistent evidence to support the firm conviction that the infringement took place, and it does so by resorting to indirect evidence. I mean, if this is also these hearsay patterns, if you have direct evidence from a company saying that no, we should fix prices, and after you have read this document, it should be destroyed. I mean, probably you do not. This would be clearly direct evidence, unless you different pattern would be if somebody says about you that you participate in the meeting, but there's no other evidence that this was the case. Then probably it would be less clear that this infringement has taken place. So so the nature of evidence really determines always its probative value, and there's also in a close relationship with the interpretation of substantive law, because I mean, as you probably know, once you if you participated in a meeting in which price fixing was discussed, yeah, this may already be sufficient, yeah, to for the reproach of for the accusation of an infringement, because since price fixing is really a serious infringement, and that any already let's say relationship with that infringement would bring you in difficulties. So the participation in a meeting which you could not, or for which you could not say that you did not attend, will probably be sufficient then to. I mean, this is what we see every day. Will be sufficient to come up with this accusation on the part of the regulator. Here, in the proceedings, the presumption often work like that there are lots of evidential presumption and legal presumptions. Legal presumption is infringement by object, competition is restricted, so you do not need to show any effects. I mean, this is what we see something like this, or that any unlawful conduct, if you committed price fixing and you stayed in the market and you continued selling, this probably then is enough to show that your subsequent market behavior also took this previous price fixing into account. Yeah, so you play a lot with this presumption, because otherwise it's also often about cartels. It would not be possible also for competition authority to demonstrate that an infringement has actually taken place. Yeah, and here I put together is also something which you may also look at in more detail. If you review the slides, there is a broad interpretation always of cartel infringement, because since it is a serious infringement, there may also be, depending on the scope, not only, I mean, if price indicators are involved, not only the actual fixing of price is enough. Yeah, you could already, I mean, if you discuss prices also with your competitors, no? This will also lead already to a cartel infringement. Also, notion of single and continuous infringement. If you did something in year 2002 and again in 2008, yeah, then you may already, or you may infer that you did not cease this conduct unless demonstrated otherwise, that you did not cease this conduct between these 6 years, yeah, in which you did not have a finding of an infringement. And the basic principle for infringement is really the for in this cartel, especially in this cartel proceedings, is that not every item as such. For instance, the fact, what I said earlier, the fact that you participated in the meeting. Not every item of evidence must satisfy the standard, but the entire body of facts, as a whole, all these pieces together, taken together, there must be a precise and consistent evidence, unless that specific item is the sole basis for establishing a given fact. I mean, there could be only one piece, but usually if you arrive at the conclusion by looking at the entire body of facts, and then the possibilities of rebuttal. This is what comes in 103. This is the last item. But for instance, if there's a price fixing ongoing, which was agreed upon in a meeting between competitors, what you could do is then the best excuse would be you just stand up, walking out of the meeting, saying that I do not agree with what was discussed here, or that you afterwards also publicly distance yourself from this cartel conduct. This is justification, but it's difficult always also to establish. But you usually do not do this, that you say, no, my competitors have agreed on prices, and I do not. I'm not like them. And you do not make this kind of declarations. The most important in these proceedings, according to my experience now, after these years in the practice, is that you come up with alternatives, how certain factors could be interpreted differently as reasonable commercial conduct. I mean, you also have to be imaginative for your clients, that you are. But sometimes also, it's like this, that sometimes that you take out one element of a context, and then you say, oh, this looks like an infringement. But if you put it back into the context, contextualize a certain conduct, you also could say that, no, this was in reaction to a general trend in the market, or they are responded to an request from a customer. This did not come from a competitor. I mean, all these kind of things. This is also important. Keeping in mind this plausible alternative explanations. And this is also the key point for takeaway. There's no defined set of evidentiary thresholds. The assessment of evidence is necessarily case specific. This is the bottom line of all these proceedings. And as far as evidentiary presumption are concerned, that shift burden to the accused party. This is also important, that is somehow more or less in line with general understanding, common sense reality. And in cartel proceedings, there's a risk of extensive interpretation of legal rules, especially also when it comes to information exchanges, that they do not involve prices. There has the entire range of possibilities that where information has been exchanged between competitors, that authorities come up with a conclusion, this is about strategic matters. This is why it should be considered an infringement. And the basic principle is always that you look at it as a whole, and that the courts themselves ask is whether the principle of unfettered evaluation of evidence has been observed. And this is about, now you see in the digital platform, there will be kind of a shift of the burden of proof, because now these gatekeepers, Google and also on, maybe you have discussed this already in one of these modules. Basically, there's a certain presumptions, and if you fulfill this presumption, there's no way of escaping of these obligations. This is why it is criticized that this digital platform really puts upside down the entire system of evidence in competition law proceedings. There's a list of ex ante obligations, and then the question is always how this matched with the enforcement powers of the European Commission in competition law proceedings as a whole. How this will play out in the future. Whether now these the Digital Markets Act powers will to what extent they will be used or preferred, or will have a preferred use over the traditional competition law powers, which probably will be more benevolent, more favorable still to lots of companies. And then the question is whether these simplification of evidential necessities, we will really justify then the outcome, and then the outcome could be, or could come at a cost, and it will be less protection and less defense rights, on the part of the companies concerned. I think I will stop here, because I agreed also with Alfonso, who will teach the class next week, that he will also cover a few items that I have not covered today. So he also some things to talk about. So I think you will, after this module, you will have all this, including investigative measures, that maybe also he will take up. So then you will have the whole range of topics covered in this module. And I just wanted to ask you whether you have any question about what you've heard after these long 4 hours. Thank you for staying with me. And but let's see if you have any question or any comments. Happy to take on your comments.
I don't see anyone.
Good, you're tired.
Yes, I suppose everyone is.
Yeah.
Thank you very much, Konstantin, for this lecture and
Thank
for
you.
this long 4 hour, as you say. I'm sure that everyone needs time to digest everything, and we will meet again for this last lecture of Module 8 next week via Zoom, and that's it. Have a nice weekend. If there are any questions, Till, do you have a question or something? No.
No. I'm
okay,
fine.
see your microphone open. Well, thank you for staying with us today, everyone. And Konstantin, it's a pleasure to have you.
Thank you very much to everybody. And
good weekend. Bye.
Good weekend. Bye-bye.
Thank you very much.
Bye-bye.
Bye-bye.